would you agree that part of the Colorado method is asking jurors to commit not to a particular verdict, but rather to commit to considering life without parole, even under more and more heinous circumstances?
Sure, that's part of it.
And did you ask questions in that form?
Yes and no. I certainly was attempting to get there. Did I ask it as I would ask it today? No.
If I may. No further questions. Thank you.
Anything further of this particular issue?
Not in this situation.
Okay, we can proceed then.
Ms. Schlax, have you ever handled a murder case where the victim was so young before Mr. Smith?
Definitely not a murder case as a defense attorney. As a prosecutor, yes.
Okay. Did you consult with trial strategists to help formulate a plan for trying such a difficult case?
We were very grateful prior to being appointed on this case. The Public Defender's Office, and I honestly don't know how it mesmerized, but Brian Stoll with the ACLU as well as Sarah Flynn had volunteered to meet and kind of be a brain trust and bring their experience with very, very difficult cases to try to give us some ideas. And I remember meeting with them, I believe, several times.
Because the evidence was rather a lot of evidence to overcome, correct?
Certainly.
Okay. Did their advice include preserving and cushioning legal issues?
Certainly.
Did you present the various options to Mr. Smith? The pros and cons of a plea versus going to trial?
I remember having extensive conversations about that.
Okay. And did you memorialize those conversations in notes, attorney notes?
Having looked back at my notes, yes, in
Okay.
abbreviated format. You always wish you would have added more detail.
Okay. If you need to refresh your recollection, in the book there, Exhibit 2 is an October 2nd note. And what basically I'm just going to ask is, what would be the pro that you discussed with him of going pleading?
My memory of, and it wasn't just one discussion. I remember us talking about this repeatedly. Some of the pros would have been to hopefully shorten the presentation of the most egregious facts. And quite honestly, we ultimately kind of came to the conclusion that's not a true pro, because even with a guilty plea, the state would have been entitled to, and I'm sure they would have presented every single thing they presented in the original guilt phase.
They just wouldn't have to hear it twice.
Agreed.
With gaining credibility with the jury by accepting responsibility, was that a pro to plea?
Yes, and then there was, and Dr. Butler, I remember having somewhat of a strong opinion that resonated ultimately with all of us, and I think probably was the largest impact on Mr. Smith, which was there's something psychologically about a jury being able to return a verdict of guilty, that now they have done justice. Justice has been served by their action, their decision, that would have an impact on how they viewed their role in the penalty.
Okay. Did you also discuss the pro of going to trial, increasing chances of appellate error?
Definitely.
Okay. But ultimately, whether you plead or whether you go to trial, and you can advise him and people can advise you, right? But ultimately, whose decision is it whether to plead or go to trial?
Oh, definitely Mr. Smith.
Okay. So were you following his wishes then when you took this case to trial?
Yes.
Okay.
Although the morning of jury selection, he came very close to pleading. But yes.
Okay. Well, And also, I think, Malik, did you capture that discussion, I think, in November 28th, 2017 notes, as Exhibit 3, if you want to refresh your recollection with that. But did you talk to him about whether or not you could concede guilt in opening statement?
Yes, I remember having discussions about that.
And was he going to allow that?
My memory is ultimately he did not want us to absolutely concede guilt.
Okay. And did he give you instructions that you weren't to do anything to hurt appellate error on the guilt phase?
I'm not sure I understand the question.
Did he give you instructions that he didn't want you to do anything that would hurt appellate error in the guilt phase, so that would hurt you capturing appellate error?
I certainly don't remember ever having discussions with that language being used. Mr. Smith would say things like, well, my largest priority is to stretch this out for as long as I can. The more appellate issues, the better.
So turning to Exhibit 3, the last page of Exhibit 3, that's the November 28, 2017 notes. It would be the last page. And it would be the last paragraph.
And I'm sorry.
Look at the, I'm sorry, if I may approach the witness, I could show her.
Oh, is it in this binder? Oh, I'm sorry.
Sure.
So I'm sorry.
Exhibit 3.
Sure.
And then it would be the last page in Exhibit 3, and the last paragraph.
Okay. And I'm sorry, what's the question?
So did he instruct you, I take it that these are notes where you captured your conversation with him from November 28, 2017?
Yes.
Okay. And did you note that he does not want to do anything to hurt an appellate error of guilt phase?
Yes, that appears to be my exact note.
Okay. So even if you thought a plea would have been a better strategy, then you're obliged to follow his wishes in this regard.
Of course, I can remember having many, many discussions with Mr. Smith that he was the captain of his own ship,
Okay.
to quote the language in the Supreme Court case.
Okay. Well, I'm going to ask you some questions about Rain Periwinkle's trial testimony and the state's questioning of her. Who handled this witness? It was you?
Yes.
Yes, okay, it was you on, okay. And who had the primary responsibility to make objections then?
I did.
Okay. Now, according to Florida Statute 90.6123, should the state ask leading questions of its witness?
No.
Okay. Unless it's necessary to develop a witness's testimony,
Sure.
which would sort of, how do you take that? I take it, do you agree it's like preliminary matters that move the trial along, or do you take it some different way?
I will tell you, as a trial lawyer, I'm not a large objector to leading questions. I will usually let any prosecutor get 3 or 4. It's only when it's a long chain. But if they're trying to move things along, I don't object.
Okay. Now, under the rules of evidence, should a prosecutor lead a witness concerning identification of a suspect? Does that cross the line for you?
It depends on the circumstance. In this case, it wouldn't have bothered me one way or the other.
No.
There was no question that Mr. Smith would be identified.
Would you consider the leading question if the state identified the witness?
I'm sorry, I don't understand.
Would you consider the leading, all right, why don't we go to the questions? That might
Sure.
make more sense rather than ask it hypothetically. So you have a binder that says testimony of Rain Periwinkle. Okay. So I'm going to review some of the questions the state asked Ms. Periwinkle trial. Please tell me if you think these questions are leading. So this is volume 2, the record at 1034, and it's line 9 to 14.
And I apologize, do you want me following along?
Only if you want your recollection refreshed.
Sure.
Okay, because in other words, and also I'm doing it for the purposes of the state, so they know what I'm pointing to. Everyone can, sort of be on the same page.
Certainly. You lost me. Am I in the binder?
Now we're going to start here on not the binder yet.
Okay.
I think for the rest of the questions, you will not be in the binder.
Sure.
Okay. know, no matter how you try to make it easier, it's
No,
gonna be
you
what's
did a
gonna be.
beautiful
Okay.
job.
Okay. All right, so, then, do you recognize the person in that photograph? Is that a leading question?
Can you go, tell me again where you are in this?
Okay, it's the record at 1034,
Okay,
and we're at line 9.
Okay.
thank you.
Yes, and I'm sorry, what's the question?
Okay, so do you recognize the person in that photograph? And the answer is yes. Is that a leading question?
No.
Okay. Now the next one, does this photograph fairly and accurately depict the way the defendant looked on June 21st when you first encountered him? And that's at line 12. Is that a leading question?
Yes. I mean, obviously, I understand your concern is that he all of a sudden inserts the defendant.
Well, the way the question is asked, does the witness tell the jury who it is a picture of? Is it the witness saying this is a picture of, or is it the defendant saying the way the defendant? Is the state telling the witness in their question that it's the defendant they're asking about?
Again, I apologize. I don't understand.
Okay.
Are you asking me to comment on how I would take that question?
In other words, I'm asking if that's a leading question. So, like, does the witness say this is a photograph of the defendant taken when I first encountered him, or is the state putting that information into the question and just asking the juror, the witness to agree with it?
Yes, I mean, he clearly inserted the defendant there.
Okay. Do you consider that a leading question?
Yes.
Okay. Is identifying the defendant a fact the state needs to prove?
Certainly.
Okay. Well, why did you not object?
This was Miss Rain Periwinkle's testimony. I had an absolute strategy that I was not going to interrupt at all.
Okay. Do you feel then that your strategy to not interrupt Rain would take precedent over Mr. Smith's strong desire to make sure he captured all appellate errors?
Yes. Yes, I do think my strategy was far more important. I don't think this was an appellate error that would ever cause the case to be reversed. I'm sure that it probably went over my head that he actually had said the word defendant. This was not a whodunit. This was definitely a case, if we were going to be successful, we were going to have to get hopefully one or more jurors to believe in Mr. Smith. Me fighting with Miss Periwinkle was not going to move that in our direction at all.
Well, you pretty much assumed you were not going to win the case, correct?
We certainly knew, as Mr. Smith did, that we were not going to be successful in beating
In
the
Bill's
case.
case. In Bill's
Bill's case. Correct.
But
But it was all
rather than expressing remorse and trying to take responsibility, his decision is go to trial
Yes,
and don't waive any appellate errors.
correct.
Okay. So turning to the record at 1037, line 5, the question is, do you recognize that to be a photograph of the surveillance video from Dollar General on June 21st, 2013? Would telling the witness what it was a photograph of be considered suggestive and leading?
Honestly, I don't think I would call this a leading question, worthy of objection.
Well, you didn't consider any questions of Ms. Periwinkle worthy of objection, according to what you said earlier.
No,
You were not going to object. Right. So,
Yes.
but was that a leading question, though? Does it contain not what is this a photograph of, where is it, or what time? that information is in the question, and the witness
Correct.
agrees with it.
And if you're asking me from a law school standpoint,
Yes.
does that meet the criteria of a leading question?
Yes.
I would still say iffy. If you're asking me as a trial lawyer, even with the benefit of hindsight and slowing everything down, I still would never object to this question.
I'd like to go ahead and make a record of whether or not you think something's leading. I think you've already pretty much told us, if I may say, that you didn't really want to object to anything. But
Correct.
that's not something I'm going to argue, about, so that's silly. But I just want to establish now for the record if you identify these questions as leading or not.
Okay.
Okay? All right. How about if we go to the record at 1053? And it would be line 13.
Sorry.
What page, I'm sorry?
1053,
Thank you,
line 13.
thank you.
Do you recognize that to be a surveillance photograph on June 21st, 2013 that shows you, Cherish, and the defendant in the children's clothing section of Walmart? Is that a leading question?
From a law school standpoint, yes.
Okay. How about, we'll go to the record at 1038, line 12. This is where Ms. Periwinkles testified that Mr. Smith had a $150 gift card and he was waiting on his wife. And then at line 12, the state asked, did he make you believe that he was going to give you or allow you to use that $100 or $150 gift card to buy items for your children? Should the state be suggesting what the defendant said versus asking, what did he say?
And again, from a law school standpoint, I think that meets the criteria of leading based on the question that was asked just right before. I obviously didn't object to it at the time. Reading it again, I wouldn't object.
Going to the record at 1042, line 22. After Mr. Smith has allegedly asked Ms. Periwinkle, would you like to see his driver's license, the state asks, did this sort of make you feel uncomfortable? Should the state be suggesting how it made her feel versus asking her to describe it in her own words what she felt?
It's somewhat semantics, but I don't know that I call that leading. Did this sort of make you feel more comfortable? Because she indicated, she answered in the affirmative and then went on to explain her full feelings. She could have easily said no.
So, at what point would you require a witness to provide details about her interaction versus allowing the state to supply the narrative?
And I'm sorry, I didn't understand the question.
At what point? At what point in the questioning? What kind of? Is there just no question the state would have asked Ms. Periwinkle in particular to provide the narrative versus the state providing and she just agreed with it? Is there like, in other words, you're okay with the state identifying the defendant and having Ms. Periwinkle just agree?
I was fine with that.
Right. And you're fine with the state providing Mr. Smith's statements and having Ms. Periwinkle just agree?
If you want to, I don't remember that specifically, so if you want to point me.
We're just going back to the one about what he made you believe.
Oh, in terms of giving
Right.
the
Yeah.
gift. Again, this wasn't a whodunit.
Right.
And so you probably have had the benefit of reading Ms. Periwinkle's deposition. There were very, very strong concerns that we would have an outburst in the court. And from a defense standpoint, we were very, very concerned that there might be some kind of response from her that was so prejudicial, but not sufficient to have the court cause a mistrial. And as we all know, you can't unring a bell.
So when you say prejudicial, but you weren't expecting to win the case, so in what way would it be prejudicial?
Again, always penalty phase.
Okay. And was Ms. Periwinkle getting favorable treatment in the media? Based on the decision?
Yes and no,
Okay.
depending on where you looked.
Yeah. So would asking her to point to something or, say in her own words, if this caused an outburst, could you have used that in the penalty phase? Used it to argue something other than grief, something more like guilt or remorse? Because you were talking, and now I'm getting into penalty phase, but you sort of brought it up, so I'm going to have to kind of go there a little bit. I believe part of the strategy in penalty phase was some blame shifting.
Certainly.
Okay. So, if there was an outburst about something as minor as tell us who this is, or tell us when this happened, or tell us where you went, could you have also used that to your benefit? Did you ever think about that?
No, there was definite considerations because we were very concerned about her testimony.
Yeah.
And she did receive all kinds of media attention, both positive and negative. But in the courtroom setting, when we know this jury is going to be presented with the full facts of Cherish's demise, and see everything up front and that mother's anguish, we wanted to limit the display of that mother's anguish, which I don't think anyone ever suggested was not sincere.
So
We
then
wanted that limited in front of the jury.
So then you could just enter a plea and show remorse. You would eliminate any question about first or guilt phase.
And I'm sorry, what's the
He could have
question?
just entered a plea, because you're not expecting to win. That would eliminate any possibility of outburst during guilt phase, and you could show remorse and gain some credibility with the jury. If you're that worried about Ms. Periwinkle and how she's going to respond to questions and how she's going to respond to telling her story, right?
Are you asking me?
Yes, in other words, you're concerned about Ms. Periwinkle not being able to handle questioning, so you just wanted to not object or not interfere, but they could have just entered a plea, and then you wouldn't have to deal with any of that. Correct?
Meaning Mr. Smith had
Yes.
the option?
Yes.
Certainly Mr. Smith had the option to plea if he wished to.
But
There were many discussions about it.
his priority was to go to trial and capture all issues for appeal. That was his priority.
Yes.
Okay. So even if the court overruled your objection, you could still appeal, right? Like, let's say you had objected and the judge overruled, you could have appealed that. You wouldn't just object if only when you were sure you were going to get the answer you wanted.
And again, I apologize, I don't understand your question.
Okay. Would you only object if you were sure you were going to? You said this would. Let me back up. You said at some point that some of these were law school textbook leading questions, which you recognize it's a leading question. Perhaps you could have objected to it, but maybe did you consider were you holding back only because of rain, or were you holding back also because you thought the court, you said, might not even grant it?
No, I think overall, in terms of leading, I knew Mr. Khalil was going to lead her to a certain extent. We'd had discussions about that. And I did not have a problem with that because I wanted her on the stand for as little amount of time as possible.
Okay. So you discussed with the state allowing him to lead.
I remember him making a comment, I'm going to lead her as much as possible.
And you said, okay.
If I responded at all.
Okay, all right. And do you agree that not objecting is consistent with Mr. Smith's decision and purpose of going to trial?
I'm sorry?
Not objecting, is that consistent with Mr. Smith's stated decision and purpose for going to trial?
Yes, at the time, absolutely. Because the purposes were twofold, and certainly Mr. Smith vacillated about that. But when we physically went to trial, and he did vacillate, he wanted us to win in terms of getting him to general population. Now that would go back and forth throughout the trial, throughout the penalty phase, but certainly my goal as his attorney was to get him a life in prison. sentence. And so, yes, I was always, our entire strategy of everything was towards that ultimate decision for the jury.
So if that's your most important goal, why would he not plead then? I'm very confused. Why would he not plead express remorse? If the most important thing, everything is geared toward is to trying to get that life sentence, I don't understand how that's consistent with going to trial in guilt phase.
Well, I feel like you're asking me to speculate why he didn't ultimately plead, and ultimately not.
Well, we have the note that you put down. Do not waive any appellate error. So is that or is that not the reason that you're in the guilt phase?
Yes.
Okay. All right. Let's talk about the rope.
Right?
The rope. Mm-hmm. And that it's going to be the record at 1051. But before we get there, if anyone needs to refresh recollection, Volume 1, the record at 1452, do you recall that the defense filed 9th motion in limine to keep out the bundle of rope? You didn't want that coming into evidence.
Yes, I remember us filing a motion in that regard.
Okay. And then going to Volume 1, the record at 4041. At line 13, Mr. Fletcher's arguing that he's disagreeing with the relevance of it. It's just prejudicial. It was never taken from the store, and the court is, I'll reserve ruling. And that's in line 17.
I can't find where you're at. What do you mean by volume 1?
Well, I'm saying this for the record, Your Honor, because there's a
That's not
volume.
anything to look at.
But in the paperwork I gave you, if you look where there's a tab, you should see that it's page 62, I think, but I think I might have written it down at the bottom, and it's 4041.
Yeah, I see it. I
Yeah.
see it now.
And
I just thought you were looking at a separate volume of.
There are 2 volumes, but for the record, I'll say when we're looking at Volume 1 and Volume 2, but it doesn't matter for you because I've kind of taken it out already.
Okay, but I found what you're talking about.
Okay, and so the court reserved ruling on the road.
Yes, that's my understanding of
Okay.
what the record shows.
Okay, so then going to back to Volume 2, at 1014, if you look at the state's opening, at line 8 to 11, in their opening statement, they're mentioning that he put only one thing in the cart, an item that ultimately didn't leave with, but one that foretold his intention, a bundle of rope. Do you recall the state making that statement in opening?
Yes, vaguely,
Okay.
and having reviewed the transcript more so.
Okay. And there was no objection?
There was not.
Why was there no objection?
We obviously thought the court had ruled that it was admissible.
Oh, okay.
We obviously, it was our mistake.
Okay. So then when Ms. Periwinkle, now going to her testimony at 1051, line 18, he's mentioning the rope. He's asking her about the rope. There's no objection there. And it's the same reason you thought that it was ruled upon?
Agreed.
Okay. Okay, and if you just turn the page, I believe the next page, starting at line 1 to 13 of Ms. Periwinkle's testimony, this is when the state is moving the rope into evidence. And so you said no legal objection.
Yes, followed by, it somewhat highlights that I obviously thought that the motion had been denied, because the next thing I say is we would renew all prior motions.
Okay. but you did not get a ruling on it, so there's not something that you can appeal.
Yes, as we
Okay.
discussed, it was our error.
Yeah, okay. All right, so, let's see. Then the next thing is I would call your attention to the part of the claim about digitally altered photographs. Volume 1, at record at 1421. It's the defendant's third motion in limine. Did you all file a motion concerning keeping out the digitally altered photographs because you thought they weren't proper to be digitally altered?
No.
Uh,
We filed a
Yeah.
legal motion.
Okay.
Yes.
And then, I'm just laying a foundation of
Sure.
what happened, okay? So this isn't, I'm not drinking on this, but just, all right. And then on February 1st, 2018, we're still at volume 1, and then the record at 4049, the third, at line 14, the court says the next one is defendant's third motion in limine regarding digitally enhanced altered videos. And she says, I'm going to deny that motion. So that motion was denied.
Yes.
You agree? Okay. All right. So, when the state went to move the videos into evidence, and that would be during Rain's testimony, so it would be at, going back to the record at 1037, and then again at 1053. I think there's 2 sets of video, and I don't know. But in both places, it was the photographs. Did you renew your objection?
And I don't have a memory.
Okay. All right, so let's look at,
If there's a specific point in the transcript.
sure, 1037, line 16. Your Honor, at this time, the state would move into evidence. Let's see, I think above it is where they're talking about the photograph of surveillance video, and then now he's moving it into evidence, and you say no objection.
That is what the transcript reflects.
Okay, and then if you go to page 1053, line 13, he's asking, do you recognize this as the surveillance photos? And then at 24, onto the next page, he's moving them into evidence. And no legal objection.
Correct.
Okay. So, is there a reason you didn't renew your objection?
I imagine at the time, I thought I had sufficiently preserved the record by, before the trial began, reviewing all prior motions. I'm sure that was my thought process at the time. It wasn't, I have no indication that I thought to myself, oh, well, we're not worried about that as an appellate issue. In my mind, I believed I had preserved that issue for appellate review.
So when you said no legal objection, you didn't understand that you're waiving your objection?
Correct.
Okay. Let's talk about the 911 call. Okay. All right. So during Ms. Periwinkle's questioning, I've already established you didn't object to any questions, correct? So
That's my understanding, yes.
So then, even to make it go quicker, I mean, the state was able to establish where she met Mr. Smith. I can point to her testimony, but is that a fair statement?
Certainly in her testimony, yes.
Where she met him, when she met him?
Yes.
Okay. Where she went with him from Dollar General to Walmart, that was established already?
Yes.
Okay. And when she realized her daughter was missing, the time frame was already questioned and established?
Yes.
Okay, I'm correct. And that when she couldn't find her daughter, she called 911?
Yes.
Okay. So all that was established, and you, as I understand, you made no objection, so there was nothing about her testimony that you were challenging with an objection?
Correct.
Okay. So then the state, and this is in her testimony here, volume 2, at page 1061, they're moving, let's see. 1061, line 19, they move it into evidence. They move the 911 call into evidence, and you have no objection.
Correct.
Okay. Are you familiar with Florida Statute 90.403 that talks about relevant evidence is inadmissible if its probative value is substantially outweighed by, and one of the things listed is needless presentation of cumulative evidence?
Yes, I'm familiar with it.
Okay. Could you have objected to the 911 call based on that, since there was nothing, or could you have? I'll just leave it there.
My memory is we had filed a motion in limine. Am I incorrect about that? About the 911 tape?
When it was admitted to evidence, the record of 1061, line 22, no legal objection.
Correct, that's what this transcript conveys.
Okay. So you had no legal objection?
That is what
That's
I
right.
said on that tape, yes.
Okay. Did you mean to object? No.
No, that's
Okay.
That's what I said, and I have no memory of thinking anything different. Those were the words that came out of my mouth.
Okay. Did you think about it being needless presentation of cumulative evidence
Yes.
and highly prejudicial?
Not at that particular moment. We were resigned to the fact that it was going to be introduced into evidence.
Why were you resigned to that?
Because my memory is we had filed a motion in limine in regards to it, and it had been denied.
Okay. But then you waived that by saying no legal objection.
Apparently, yes.
Okay. All right. Now, final thing is I want to ask you about, so the state filed its first motion in limine to exclude certain evidence of Ms. Periwinkle's personal history. And that would be at volume 1, the record at 752. And that would be this document here.
Yes.
Okay. And then the court's order, perhaps the parties can help with this a little bit. The court made an order at volume 1, record at 830, and the order is sort of coordinated in referencing Ms. Periwinkle's deposition. Is that correct? Go ahead.
Memory? Where do you want me?
So it should be order on state's first motion in limine. It would be a piece of paper.
Is that a particular number?
Just kind of, I can approach and find it for you if you'd like.
I think that's a good idea. I mean, I found it, but
It'll just take a second.
not that easy because it's not,
Okay. So this was the motion and this was the court's order. Okay. And I apologize. What was the question?
Okay, so when you look at the order, it seems to be coordinated and it's referencing Ms. Periwinkle's deposition.
Yes.
Okay. But I did not see in the court file a deposition. I would like to enter that into evidence along, but let me get through these questions. But this order is referencing stuff that's in the deposition, and you wouldn't really understand what it is unless you had the deposition. Because it's just saying line, page 6 of a deposition, or page 7 of the deposition. So,
Your Honor, we have no objection to them admitting the deposition. I believe at the motion hearing the deposition was admitted as an exhibit, so we have no objection.
okay.
and I'm not sure, but I'm imagining this should be held as confidential in the clerk's file. He's got probably the stuff. I'm sorry. This is for the clerk or the court to decide, but I'm thinking that there's might be sensitive stuff that you would want, if I file it, it should be filed as confidential.
Mr. Cleo?
Your Honor, I would agree there are some discussions during the course of the deposition that involve medical treatment in counseling sessions, things of that nature that would be confidential in nature,
Okay.
so I would agree.
Okay,
It should
so
be filed as a confidential.
I agree.
Okay. All right, I'll hand this to the clerk in just a second, I might still need to correct it. So basically then, going through the court order, what was excluded is other names she could go by. Is that correct? Do you remember, or would you like to go through it and find it on each page?
No, I have no reason
Okay,
to
okay.
to believe that your representations aren't accurate. You've gone through the transcript much sooner than I have.
Okay, and so also the court ordered to be excluded any Baker Act commitments.
Yes.
Okay, and any prior physical or sexual abuse.
Agreed.
Okay, but then on page 36 to 40 of the deposition, there were some things the court was going to have the parties proffer after Ms. Periwinkle testified, and then make a ruling on whether or not these matters could be addressed on cross. And so the proffered items included any diagnosis of mental disorders and any psychological hospital commitments.
Yes.
And also false testimony that might have been given under oath. That's at page 40 of the depo. That was to be proffered. And then Ms. Periwinkle being clairvoyant. That was at page 46 to 48 of her depo, and also page 53. Those last three things I mentioned were items the court did not rule on, is that correct? And that we're going to be set off after Ms. Periwinkle testified on direct for the parties to then argue those last remaining items before you cross-examined her. Is that your recollection?
I honestly don't remember if.
Well,
No, what I'm saying is I honestly don't remember it in my mind when I stood up to cross-examine Ms. Periwinkle if my intention was to ask the jury to be excused to proffer.
Well,
I kind of think I was standing up to begin my cross-examination, and my plan had been at any point I may have had to take a short recess to go ahead and proffer it.
it might help. I have one more piece of the record. It's volume 2.
Sure.
It's the record at 996. And it's Mr. Khalil addressing the court even before opening statements. He's letting the court know there's a fairly lengthy motion in limine regarding items pertaining to her testimony. And so he's suggesting the most logical way to proceed after the state finishes their direct to excuse the jury, allow the proffer, and then make a ruling.
That
Okay.
helps refresh my memory
Sure.
that obviously I must have been standing up to ask for the jury to be excused, to do the proffer.
Okay, so now, with the jury out of the courtroom, before you begin, did Mr. Smith tell you something about, did he, at this point in time, is he talking, does Mr. Smith make a request of you concerning cross-examination?
Yes.
And what is he telling you?
I have a fairly distinct memory of this moment because I remember he physically grabbed my arm and said emphatically and somewhat loudly, "Don't you dare cross-examine that woman. Either she's been through enough, or leave her alone."
Okay.
It was a very strong statement.
Okay, and how long did you discuss his request with him? Or at that point, did you just turn around and make your motion to the court for there to be a colloquy concerning cross-examination?
My memory is it was very quick.
Okay. Like no discussion, or you just relayed his request basically to the court?
My memory is I relayed it very, very quickly
Okay.
because I was thrilled with it.
So you didn't ask for any time to discuss this new decision with him?
Correct.
Okay. By not having the motion in limine then, and not by waiving your cross, you've now waived the court's ruling, is that correct? Concerning the state's first motion in limine, that you've waived what she ordered, you've waived what the court has ordered needed to be excluded from Rain's testimony. The court made a ruling about what could be asked of Rain on cross, correct? So when you waive cross, you're waiving her ruling on what's excluded because you're waiving cross. It's irrelevant.
Sure.
Are you also waiving any argument about the proffered items that you wanted to be able to ask on cross?
Yes.
Okay. Did you make it clear to Mr. Smith that if you go forward with this plan of his, he is waiving these appellate issues?
I sincerely don't think that particular discussion took place at that time because we immediately went into the colloquy.
And, okay, there's no, why did you not feel it necessary to explain to him about the consequences of his request?
We had had extensive conversations about how the appellate process worked in all of our jail visits. You know, in terms of the initial brief, and that, you know, everything is picked over, and then ultimately there may be oral argument, etc., and that's a continuous process. I will tell you, I don't ever remember having a conversation with him, you know, it would be great if we can object 50 times versus 0, because that's going to make a difference in the length of time for appeal. I don't remember any kind of discussions on that, nor would I honestly ever advise them of that.
So you didn't feel he needed to understand what he was waiving here when he made that request?
I felt he fully knew what he was waiving and had made the strategic decision that he thought he would curry more favor with the jury by not having me beat up on Ms. Periwinkle, which is what he had always previously wanted me to do. Those were my marching orders. And because of the way, the dynamic of this case, and that Mr. Smith nor ourselves ever thought there was any chance that Mr. Smith would not be found guilty of the first-degree murder of Cherish Periwinkle. And so the only effort in going to trial is an attempt to defeat the death penalty. And so I had told him numerous times that I understood he had very strong feelings about Ms. Periwinkle and her alleged kind of involvement in Cherish's demise, that I did not think strategically that would curry much favor with the jury and would probably work against us.
So he gave up pleading guilty, showing remorse, taking responsibility in exchange for preserving appellate issues which you didn't think were of any value. So then you didn't bother to preserve them?
No, again, his thoughts of what he wanted to happen vacillated sometimes minute to minute.
Okay. So you've made notes of capturing his wishes concerning plea versus going to trial. Are there any notes where you indicated at all that he wanted to change his mind about that?
And I'm sorry, you're talking about the moment that it was time for me to cross-examine Ms. Periwinkle?
At any point, have you made a note or anything to memorialize the idea that he actually didn't want you to preserve appellate issues?
And I can guarantee you Mr. Smith never said the word appellate review, appellate issues to me. He would say things like, I want this dragged out as long as possible.
Well, in the note that we had looked at Exhibit 3, you had noted he didn't want to do anything to hurt appellate error.
Correct. That's
Okay.
That's my language of the long discussions that we had.
Okay.
Yes.
And do you have any note that contradicts that note?
No,
Okay. Thank you.
Mr. Cleo?
Yes, ma'am, thank you. Good morning again.
good morning.
Ms. Schlax, isn't it true that there is a well-used defense strategy that when you're trying a case, you do not want to object simply for the sake of objecting?
That is my personal strategy and the way I've practiced law for 20 years as a state attorney as well as a defense attorney.
Well, and the reason for that is if you constantly are standing up and objecting, when in your mind you know that the evidence is coming in, particularly on a leading question, because all the prosecutor needs to do is rephrase the question, a defense attorney will look like an obstructionist.
I must admit that's always been my rule of thumb.
And oftentimes that alienates a jury, because when you're constantly objecting and being overruled, a juror can sit there and say, why are they trying to hide this information from us?
Correct.
And that it is a commonly used, and you use a strategy, that good trial lawyers should only object when, one, the objection will be sustained, and two, when the objection is material to the defense that you're putting forward.
Yes.
You and I have known each other for a very long period of time, correct?
Yes.
In fact, we went to law school, and I was a witness for you in mock trial.
Yes,
Okay. We worked together for 13 years at the state attorney's office.
we did.
We tried homicide cases together.
We have.
We tried homicide cases against each other.
Yes. Yes. Before Mr. Smith. Yes.
There were some questions that were posed by the defense during the course of this hearing that may or may not be law school objectionable when it comes to leading with Rain Periwinkle. Given your experience with me, did you have any concerns that had you objected that somehow that evidence would have been omitted from the trial with Donald Smith?
No.
Okay. And in fact, we had conversations because this was going to be an extremely emotional experience for the victim in this case, Ms. Periwinkle.
Yes.
And that there was, as evidenced by the deposition transcript and items that had been taking place in the media, that Ms. Periwinkle was very emotional.
Yes.
And it was a defense concern that during either direct examination or potentially during cross-examination, that Ms. Periwinkle may become emotional, and that would affect how a jury receives her testimony.
Yes.
And so did you make the strategic decision not to object for these questions when you knew that evidence was coming in anyway?
Oh, 100%.
Point blank, the evidence of identification in this case with Mr. Smith was overwhelming, correct?
Yes.
He was on video at Dollar General with the victims, correct?
Yes.
He was on video at Walmart with the victims, correct?
Yes.
He was arrested, still wet from the water, where he discarded the body of Miss Periwinkle, correct?
Yes.
His DNA was all over her body, neck, private areas. There was no issue of Mr. Smith's guilt as to what he did in this case.
The evidence certainly was overwhelming.
So you took the strategic decision with questions which, quite frankly, you even indicated some of them are not leading questions, correct?
Correct.
Because to be a leading question just doesn't call for a yes or no answer. To be a leading question, the question has to suggest the answer within the question itself, correct?
Yes.
So you felt it strategically not important, and actually you did not want to object because that could be viewed poorly by the jury.
Yes.
And you had no concern that the state of Florida was going to be able to introduce this evidence, even if you did object to those questions.
Correct.
And there was some discussion about blame shifting. It was never your intent or strategy in this case to blame Ms. Periwinkle for the death of Cherish.
No.
It was your intent to blame the state of Florida based upon other items that we'll discuss later on in the penalty case, correct?
Yes.
And in fact, you had grave concerns about, for lack of a better term, beating up or making Miss Periwinkle emotional because of how a jury could be enraged or angered by that action.
I was very concerned about my cross-examination, yes, as well as any objections.
Even to the point that you had extensive discussions with the defendant prior to trial, and that you, in fact, were trying to convince him not to cross-examine Rain Periwinkle.
Yes,
But he was persistent in he wanted you to cross-examine Ms. Periwinkle
yes,
prior to trial.
yes.
Is it safe to say that, given your legal experience and your strategic position, that you felt that that was not the best course to take?
Yes,
And I think you even said that you were relieved when he grabbed your arm and said, "Don't do it, don't cross-examine her," because that was your strategy all along.
yes, in my mind, yes,
Because you were fearful that if you stood up and Ms. Periwinkle became emotional and that you went after her vigorously in cross-examination, that the jury would resent you and Mr. Smith.
yes,
And again, guilt or innocence wasn't your concern here, it was punishment, right?
yes,
And that resentment could affect how a jury would view the penalty phase of this trial, and that they may be more inclined to impose a death sentence if they were angry at the defendant for doing this.
yes.
Let's talk a little bit about the rope. Based on the medical examiner's testimony, the mechanism of death in this case was ligature strangulation, correct?
Yes, that was her testimony.
And the forensic evidence even indicated that Mr. Smith's DNA was on the victim's neck.
Yes,
And it was the clear testimony of Ms. Periwinkle that the only item that was placed in the shopping cart during their time in Walmart by the defendant was the rope.
yes,
Understanding that you filed a motion in limine, hindsight looking back at it because you're an experienced trial lawyer, do you find that evidence to be relevant given the manner of death and the testimony that was presented in trial?
I was not surprised at the court's ruling.
Because clearly, the fact that the defendant killed the victim by ligature strangulation and that he put a potential ligature in the cart, that could be argued as relevant evidence in the case.
I certainly understood that was the state's argument, yes.
Same with the 911 call. While there can be arguments as to cumulative evidence, an independent present sense impression in an excited utterance, regardless of it being cumulative or not, is admissible evidence, correct?
Yes,
And so, again, if you know this evidence is going to be coming into evidence, why would you stand up and object and, again, look like an obstructionist to the jury?
yes,
Same with the still photographs. There was a motion in limine hearing in regards to those videotapes, correct?
yes,
And the court made a ruling that those videotapes were admissible.
yes,
And there was no controversy that those were, in fact, absent maybe a circle or a bubble that sort of followed the participants of this event throughout the course of the videos, that those were the exact videos of the surveillance videos from Dollar General and Walmart, correct?
correct.
So from an evidentiary standpoint, there was no legal objection based upon the law from keeping those videos out of evidence.
Correct.
And in fact, a still photograph from a video that's already in evidence is equally admissible because it is just a single slide or a single frame of that videotape.
Yes,
Did Mr. Smith make it clear to you when he grabbed your arm that he did not want to cross-examine Ms. Periwinkle?
yes. There was no doubt in my mind.
And it was emphatic, and it was loud enough that actually it was captured by the media who was present in the courtroom.
very much appeared to me to be a specific show, and I was fine with that.
And when you mean a specific show, you mean that the manner in which he did it was done so in a way to make it seem like he was human or sympathetic to Miss Periwinkle's plight.
Yes.
And it was done in open court in show of the meeting.
Yes, and more importantly, in full view of the jury.
You felt that he did that intentionally to try to curry favor with the jury.
Yes.
And prior to you going to court, you had fully discussed that option, and it was your recommendation not to cross Miss Periwinkle because of the fear of how it may be viewed by the jury.
Yes. I can remember having multiple conversations about how our demeanor in front of the jury.
And following your announcement, there was a colloquy between the court and Mr. Smith where he acknowledged that was his independent decision not to cross-examine Ms. Periwinkle.
Yes.
And in fact, the court even informed the defendant that this was his only opportunity and that he would be waiving that opportunity,
Yes.
and that he voluntarily waived that right.
Yes.
Thank you, ma'am. I don't have any further questions.
Just two brief questions.
And the first one, before I forget, because I forgot the first time, here's Exhibit 5.
What is that?
That's Exhibit 5, Rain Periwinkle's deposition that we talked about
Oh.
moving, and I didn't hand it to anybody. So
Okay.
Madam Clerk. Thank you. All right. It's Exhibit 5, Defense Exhibit 5. I'm not sure how you do it in this jurisdiction, so it's probably the second exhibit that was entered today, but on defense exhibit list that was filed, it's number 5.
All right, so defense, exhibit 5 for identification. And you're asking for that to be admitted, correct?
Correct.
Any objection?
No objection, no.
That'll be admitted as defense exhibit 2 for the hearing.
Okay, just briefly. On cross, Ms. Schlax, you said concerning the road, you were not surprised about the court's ruling.
Correct.
That at volume 1, the record of 4041, the court reserved ruling. There wasn't a ruling.
And again, as we've established, that was our error.
Okay,
We believed the court was going to allow that in, and obviously, I'm still under that belief that she would have permitted it.
I just want the record to be clear about that, okay. And then the other one, I'd like to turn to volume 2, the record at 1073. This is in, right after Ray's testimony. The 911 tape is played on 1072. If you go down to line 22, ladies and gentlemen, this is a good time for a short break.
I'm sorry, did you say 1073?
Well, on 72,
Oh.
they take a short break, I'm so sorry. The court is telling them, the jury at line 22, they're going to take a short break. Turn the page. So now at 1073, line 2, jury absent. And then the court addresses you, Ms. Schlax, at line 3, and then line 4, you're talking about my client's indicating he does not want for me to cross-examine Ms. Periwinkle.
Yes,
So the jury's absent.
yes.
Okay, on cross you had said that he had done this as a sympathetic ploy in the full view of the jury.
My best memory is that the reason the jury left was because he had just grabbed my arm.
But as we looked at earlier, the court intended to take a recess at the end of Ms. Periwinkle's testimony, and you can see in 1007, the previous page at line 20, Mr. Khalil says, I don't have any further questions, and right away the court says, ladies and gentlemen, this is a time for us to take a short break. If you would please step into the jury room, please do not discuss the case among yourselves. So there was already a plan to break at the end of her direct. Mr. Khalil is saying, I don't have any further questions, and then there's a break.
And I will tell you my sincere recollection is him grabbing my arm happened in front of the jury. And that's why I immediately went into, my client has just indicated to me that he does not wish me to cross-examine. Since the jury was out of our presence at that point, that's why we moved straight into the colloquy. There might have been an opportunity where I had a brief conversation with him. I honestly don't remember that. But I do. This case in particular, I obviously have a little bit better of a memory than maybe another one I tried 6 months earlier or later. But that particular moment, and I will just tell you humbly, it was because I did not want to cross-examine Ms. Periwinkle.
Sure.
I sincerely did not sleep well the night before. I remember that so distinctly. And I remember being pleased that he had done it in front of the jury.
Okay, so even though the record's saying the jury's absent and...
Because I think he did it as the jury was leaving.
Okay, all right. So it's not clear what they could hear, or, I mean, there's...
I will tell you sincerely, and ask Mr. Fletcher and perhaps Ms. Butler as well, because I think all of us will have the same memory. It is a very clear memory that he did it in a very flamboyant fashion such that no one in the courtroom missed it.
Okay, thank you.
And the only thing I will tell you, I also have a memory of Ms. Schindler walking up to me after, like during one of the breaks, asking me specifically, did I think that my client had done that for the jury's benefit?
Okay, thank you.
Okay, now there's one more part to this, correct?
Correct.
Do you have any idea how long that'll be?
Direct will be between half hour and 45 minutes.
Does anybody need a break before we?
Just very brief comfort.
Yeah, we'll have a 10-minute comfort break, and then we'll come back and we'll do this so she can be excused, and then we'll take a lunch break after we've concluded. Okay? We'll be in recess for 10 minutes, which is 12:03.
Did you ever ask her about that? About why she didn't consider that mitigating?
Honestly, I don't have a memory.
You said that there were multiple conversations, including conversations after she'd been deposed and after she'd said she didn't find anything mitigating.
Correct.
Did she say anything to you to give you reason to believe that she would soften that opinion at trial or change it in some way?
Dr. Holmes and I definitely discussed particular questions that I would ask her, but overall, we knew that it was a double-sided sword to put her on.
And you knew that although she testified that she couldn't see any signs of organic brain damage, you had a neurologist lined up and a radiologist and a neuropsychologist to testify about the extent of Mr. Smith's organic brain damage, right?
Correct.
And you allowed her to testify that she didn't see any, despite the fact that she wasn't a neurologist, that she hadn't viewed any of the imaging studies, and that she hadn't even conducted any psychological testing herself, correct?
And I'm sorry,
And
what was the question?
You were aware, you knew that despite her opinion that she didn't see any organic brain damage, in fact, she wasn't a neurologist, right?
Correct.
And she hadn't seen any of the imaging studies that your other experts had done, correct?
Correct.
And she had, in fact, she hadn't even conducted any psychological testing herself, correct?
No, my memory is she did not.
Okay. So wasn't that opinion of hers beyond the scope of her expertise in this case?
Yes, definitely.
Did you object to it?
I honestly don't have a memory.
You also allowed her to testify about prior sex-related crimes that Mr. Smith had been convicted of, even though the state would have been barred from getting into that on their own accord, correct?
Yes, that was a specific strategy, yes.
Fairly risky strategy then.
Absolutely.
But you allowed her to take the stand. Why? Because you didn't think you could get anybody else to get in the information about the failure to commit to Jimmy Rice?
Yeah, I mean, there was a definite strategy in calling Dr. Holmes. I will absolutely concede it's controversial. It was something that we thought long and hard about, enough so that we actually had a meeting with the assistant state attorneys to preview to them that we had every intention of doing this.
Okay, so
Dr. Holmes, we felt, was the best way to facilitate that information. With that decision, and there were a lot of conversations, and it became the specific strategy to highlight his criminal life. My memory was that we introduced all of his booking photos, that we were trying to show him as an institutionalized man, and that is where he belonged.
And you needed Dr. Holmes to bring out that information.
Certainly, in regards to understanding the Jimmy Rice and to fully explain, yes.
Well, the fact is you needed somebody with a doctorate in psychology, correct?
Well, certainly someone who had participated in Jimmy Rice evaluations, someone who had testified previously in Jimmy Rice, yes, absolutely.
Did you need somebody who knew what the Jimmy Rice qualifications were? The qualifications for commitment to the Jimmy Rice program?
Sure.
And did you need somebody who knew about Mr. Smith's history?
Sure.
And you needed somebody who knew about the prior diagnoses that had been done on Mr. Smith?
Yes.
You didn't necessarily need somebody who to diagnose Mr. Smith in 2015 or 2016 or 2017 about his mental condition in 1999 or 2000, did you?
And I'm sorry, I don't understand the question.
You didn't need to hire somebody to diagnose Mr. Smith's mental health condition at the time you were seeing him to testify about what other doctors had opined as to his mental health condition in 1999 and 2000 when they were considering putting him into the Jimmy Rice program.
And I apologize, are you asking me whether I could have used someone else
Yes,
to accomplish the same thing?
yes.
I mean, certainly, I'm sure other people could have been hired.
You had somebody
we
on your
had
team
hired-
already, didn't you?
I'm sorry?
You had somebody on your team already, didn't you?
Are you referring to Dr. Butler?
Yes.
No, that was honestly never a consideration.
Why not?
Number one, because of the extensive conversations that she had with Mr. Smith, we very reluctantly used her as a fact witness, but were extremely concerned that the state, had they elected to depose Dr. Butler, they might have uncovered statements that Mr. Smith had made that were of an incriminating nature. We had very, very strong concerns about that.
An incriminating nature in this case?
In other cases.
Okay. But you took that chance in putting her on anyway, later on in your case as mitigation specialist, correct?
We made the decision, and I want to say it was roughly December, maybe even late November, but going into December, we had come to the conclusion that we were not going to be able to have a civilian witness that could somewhat tell his life. Mr. Smith did not want his mom to have to do that role. He certainly, his son would not have been in a position to do that role, but his son was the only civilian witness, my memory is, that we put on. And so we needed someone to get out some of those factual circumstances of his life. And we ultimately made the decision that Brooke was in the best position to do that. And at that point, we started limiting her contact with Mr. Smith. In fact, my memory is that maybe she did not see him from the beginning of December till the actual trial.
But the danger of the state disclosing our prior conversation still existed through her testimony as a mitigation specialist, correct?
Certainly.
And because, like I said, she would only be testifying about other people's prior diagnosis, she wouldn't have to diagnose herself, so she didn't have to be a Florida licensed psychologist to be able to testify to that, correct?
I sincerely, it was never, ever a consideration, so I'd just be Monday morning quarterbacking myself. Honestly, it's too speculative, because it sincerely never, ever would we have considered doing that.
Okay. And your purpose in that testimony was to show what a danger Mr. Smith was to the community and how much warning the state had about that prior to releasing him to the community by not Jimmy Rice incarcerated, correct?
Well, it was that, and then to Mr. Smith, and quite frankly to me as well, was to use that with his about, I want to say, 2 weeks, and it might have been more like 4 days, but very shortly before this occurred, Mr. Smith tried to Baker Act himself. And we wanted to highlight that over and over again, that he recognized that he needed to be institutionalized. And therefore, in the hope that jurors would go on that wavelength that he is just somebody that needs to be institutionalized, i.e. not killed.
So, you offered the penalty phase closing argument in this case, correct?
I did.
That was basically your last chance to talk to the jury.
Sure.
And it was important for you to lay blame on the state attorney's office, on HRS, on the Jimmy Rice program, correct?
Yes, that was definitely one of our themes, yes.
I have a copy of your penalty phase argument for your use. May I approach her? I have a copy for the court as well.
While you're approaching, the two doctors you asked her questions about were Dr. Butler and who else?
Dr. Holmes.
That's right. Thank you.
it have been important for you in your closing argument to have mentioned the state attorney's office?
I don't know if that, I remember thinking at the time in terms of what I'm going to truly try to have this jury focus on.
Would it have been important for you in your closing argument to have mentioned the Jimmy Rice program or HRS or DCF, which administered it? If that was your theme.
Yeah, and again, I'm not sure I understand the question.
Would it have been important for you to actually lay blame on those institutions if your intent was to lay blame on them?
And we have done that throughout the trial. You mean in terms of focusing on it in my closing argument?
Or at least mentioning it?
Honestly, I've listened and read my closing argument probably 10 times since I gave it.
Well, the only
Will
reference
I
see...
always go back to, are there things when you sit down, and I sincerely have yet to have a trial where I didn't sit down and usually immediately, as well as going into the middle of the night, are there always things, I wish I argued this more thoroughly, or did I lose my train of thought? Yes, absolutely.
Do you think it would have been useful for you to address something other than the system having failed?
And I apologize, I don't understand the question.
Okay. If you would look on page 2133 of your closing argument,
Sure.
lines 18 through 21. That is your only reference to this entire argument, this entire line of defense in your closing argument.
Okay.
And you just call it the system, right?
Yes.
And you preface it with not to play the blame game, but when in fact you're trying to blame parties of the system, right?
Certainly.
And if it was such a vital part of your defense that you exposed Mr. Smith's criminal past to the jury when it could have otherwise been concealed from them, wouldn't it have been important to have mentioned that aspect of your defense on something other than the 10th page of a 14-page long argument?
Again, in hindsight, I always want to give another closing argument. Do I believe that there are words that I could have said that would have been more eloquent or more thorough? Unfortunately, yes. Every single trial I've ever done, that is the overwhelming feeling I leave with. We do that as lawyers. We second guess ourselves every single argument. Even when we win it, when we're successful, I will dissect my closing argument and wish I had argued something more thoroughly.
Do you think it might have been a good idea for purposes of primacy or recency to have maybe addressed it at the beginning of your closing argument or ended with it at the end of your closing argument rather than tuck it in the middle?
And I don't even know that I can form an opinion on that. My opening and my closing specifically was something that was completely drafted in its entirety before I stood up. There's obviously points I want to make during a closing argument, and I'm not the kind of attorney that can write out verbatim a closing argument of 45 minutes and stick to it. Just the way my mind works, I'll hit on different things at different times. So it's difficult for me to answer that question.
If I could have one.
You may.
No further questions.
Mr. Flail?
Thank you, Your Honor. Ms. Schlatt, you had previously mentioned that prior to your involvement in the case, that the Public Defender's Office had consulted with the ACLU, correct?
Yes.
Isn't it true that both the ACLU and Dr. Butler highly recommended involving Dr. Heather Holmes in the Smith defense?
I can 100% say Dr. Butler did. And I believe we discussed it in front of Brian Stoll, but I don't have as clear of a recollection about that.
Well, and the reasoning behind that is Dr. Holmes is a fairly renowned expert that is often utilized by defense attorneys across the state of Florida in mitigation practice, correct?
Yes.
And in fact, as we discussed earlier today, Dr. Holmes is testifying in a defense case in Daytona Beach later on this week.
I had never previously worked with her. Dr. Butler had, and my memory is Dr. Butler is who supplied her contact information and such.
Okay. So let's go back a little bit and sort of go through sort of your discussions, because your defense strategy in this case sort of evolves through conversations with the defendant during the course of the representation, correct?
Yes.
Okay, and dating back to December of 2015, you had extensive conversations with the defendant, and at that point in time, he expressed a sincere desire to be on death row, correct?
Yes.
But in that same discussion, this is when the theme first came up that he could be the face of a quote-unquote movement for better mental health resources.
Yes.
And in fact, again, emphasizing the exact same words that you used in closing argument, that this was a failure of the system.
Yes.
Okay. And so the entire process of all of the mitigation experts that were called, not just Dr. Holmes, but Michael Boston was called as a legal expert, correct?
Yes.
You had neurologists that were called to the witness stand. Dr. Wu testified. Dr. Buffington testified. All that was geared towards developing a complete picture of who Mr. Smith was and how the system failed in incapacitating him.
Yes.
Moving on to December of 2016, some 2 years, almost 2 years before the trial actually went, you met with the defendant and discussed how the defendant, and these were his words, should not bear the full responsibility of this tragedy, correct?
Correct.
And that this was a perfect storm of failures, in essence.
Yes.
And an indictment of the SVP, or the Jimmy Rice system itself.
Yes.
And again, this whole theory was deeply discussed with Mr. Smith in trial preparation.
Yes.
I think you've mentioned this, but I want to address this as well. You called Dr. Butler to the witness stand because outside of the defendant's son, there were no civilian witnesses who were willing to testify on the defendant's behalf.
That's correct.
And in review of the defendant's history and background, what we refer to as traditional mitigation evidence, there wasn't any for Donald Smith, was there?
It's always in the eye of the beholder. Dr. Butler went to great effort of spending time with Donald, and although they were reluctant to participate, they were willing to participate in interviews. And Dr. Butler, I think, interviewed well over 75 people that had encountered Mr. Smith in his life. And so she was attempting to get a full picture of things that troubled him. And I would certainly argue there were things in his background that were mitigating.
Okay. But when it came to the presentation of that evidence, you had to rely on Dr. Butler because coworkers, neighbors, friends, people of that nature refused to testify on Mr. Smith's behalf.
Correct.
And he didn't want his mom to testify at all. He didn't want to subject her to that.
Correct.
In a meeting in October of 2017, you discussed specifically the strategy of pleading guilty versus going to trial, correct?
Yes.
And I think
the notation is on that day, but we probably had 7 or 8 discussions about that.
And you discussed on how pleading guilty could actually increase the defendant's credibility, correct?
Yes.
In front of the jury. And you already talked about how it could potentially reduce the evidence itself.
Yes.
The damning evidence that may be presented in front of the jury, correct?
Yes.
However, the trial might increase the possibility of appellate error. That was discussed, correct?
Yes,
But it wasn't the defendant's words of appellate error. He just wanted to drag this thing out, correct?
Yes. We were not using phrases like appellate review or,
Safe to say, based upon his desire, he had no interest in being in general population because he had a fear of being harmed in general population.
yeah, Mr. Smith was very, very eloquent in his when he was of the opinion that he would prefer a death penalty sentence because of the accommodations. He was very articulate about it. It was well thought out, and fear of the other inmates was high priority in that.
And I believe you previously stated discussions with Dr. Butler in this regard that there was this theory, I guess sort of a psychological theory, that by going to a trial phase and requiring the jury to check that box saying he is guilty of first-degree murder, that psychologically allows the jury to say, oh, I found justice, and somehow that may give them more, or have them be more apt to impose a life sentence versus voting for death.
Yes.
And that was discussed with this defendant as well.
Oh, yes, extensively.
In discussing also back in August of 2017, the defendant wanted to focus on the penalty phase, correct?
Yes.
He wanted to focus on the fact that he sought treatment but was denied treatment.
Yes.
And you felt, based upon the examination and conversations with Dr. Holmes, that Dr. Holmes' testimony was the best to flush out those issues.
Yes.
And in fact, you had a conversation, a phone conference with Dr. Holmes in September, to be exact, September 5th of 2017, where she testified that she could testify and, in essence, serve as an indictment of the system that could have prevented the crime had they acted more appropriately.
Yes.
In fact, wasn't it Dr. Holmes' opinion, and she expressed this to you, that when she read the Jimmy Rice report, I believe it was from Chris Roberson, she actually was concerned that it may have been a typographical error, in fact, that the report read as if Mr. Smith should have been committed under the Jimmy Rice Act, but for whatever reason, the evaluator's final conclusion was he did not meet the criteria.
Yes.
And that was something that Dr. Holmes was able to flush out based upon her experience with Jimmy Rice and the sexual violent predator system that was in place in the state of Florida.
Yes, and her familiarity with how these reports were written and what type of testimony was necessary.
And you discussed with Dr. Holmes, in essence, the theory that the same government that's now seeking the death penalty against Mr. Smith was, in essence, the one that dropped the ball and could have potentially prevented the crime.
Yes.
Later on in November of 2017, you had a follow-up conference with Dr. Holmes where you discussed her testimony, correct?
Yes.
And this was even before a report or a deposition had been tendered to the state of Florida.
Yes.
And you specifically expressed to her that she was not burned, using your terminology, because I think that was a direct quote, and that she could testify about the system failures, meaning the criminal justice system and the SVP failures in this case.
Yes.
And she was clear to you that, in her opinion, in that conversation, that Donald Smith was a textbook sexual predator.
Yes.
You further met with Dr. Holmes, or with the defendant rather, later on that month, discussed Dr. Holmes' testimony, went through all the mitigation in great detail, and confirmed Mr. Smith's desire to present Dr. Holmes as a witness in that case.
Yes, and that entire theme, because that also included introducing Mr. Boston's testimony as well.
Right, and to be clear, Mr. Boston's testimony traditionally would not be admissible. Had the state of Florida sought to introduce the extensive criminal history that Mr. Smith had, we would have been prevented from doing so.
Correct.
and you called Michael Boston specifically as a legal expert to go through his extensive criminal history, talk about the multiple opportunities that the state had to incarcerate him, and what his potential exposure was.
Yes.
And that would not be admissible if the state had sought to introduce that.
Agreed.
However, you felt in the strategy, which Mr. Smith agreed with, would reinforce or bolster the theory that the state dropped the ball and had multiple opportunities to incapacitate Mr. Smith but failed to do so.
Yes.
And in fact, even when we get to the trial and the enumeration of what were over 100 mitigating factors, a lot of this was flushed out in specific requested interrogatory mitigation that you requested at the conclusion of the penalty phase.
Yes.
Because you were putting forward to the jury that this is mitigation, and we hope that you find this as mitigation in this particular case.
Yes.
And at the same time that you confirmed and Mr. Smith acquiesced and agreed to call Dr. Holmes for that purpose, he again said he didn't want to concede guilt at trial. He wanted to have a guilt phase, correct? And he wanted to drag out the proceeding the best that he could by not conceding to what would be admissibility issues or error issues.
Yes.
You followed up that conversation only a couple of weeks later where you again discussed the pros and cons of pleading guilty or going to trial, correct?
Yes.
And again, it was his desire to utilize this strategy of, for lack of a better term, painting a picture that he was a monster.
Yes.
You were present for Dr. Holmes' deposition on January 15th of 2018, correct?
I was.
And that was only a matter of a couple of days or a couple of weeks prior to the commencement of this trial.
Yes.
Nothing that came out on direct or cross-examination during the course of that deposition was unknown to you previously, was it?
No, there were no surprises.
You knew exactly what she was going to testify to ahead of time.
Yes.
You had spoken to her on multiple occasions about her testimony.
Yes.
You discussed that testimony with your co-counsel, Mr. Fletcher.
I did.
You discussed that with the mitigation expert, Dr. Butler.
I did, although I'm not sure because Brooke had become a witness. I don't know if after the deposition, I had many discussions with Dr. Butler, but I don't know if we had any specific discussions about Heather Holmes.
Okay. And only 2 days after Dr. Holmes' deposition on January 17th, you again had an extensive conversation with Mr. Smith at the Duval County Jail about the penalty phase.
Yes.
You went over all the witnesses and you confirmed with this defendant all the witnesses that you intended to call at trial.
Yes.
And you confirmed Dr. Butler's role in that process as well.
Yes.
You actually went through all of the enumerated mitigating circumstances that you were going to be seeking as well.
Yes.
And you all corrected some and excluded some, but the ultimate final list that was presented to the court was something that you'd gone over with extensively with this defendant.
Yes.
And that conversation was a very long and detailed conversation with the defendant.
Yes.
All of that contemplated calling Dr. Holmes as a mitigation witness in this case.
Yes.
Fully understanding how it was, in your words, a double-edged sword, and how there was some good that could come of that, but obviously there would be some bad.
Yes.
You talked a little bit about bringing that information forward to the state attorney's office. Why was that?
We were always in hopes that we could convince the state attorney's office to allow him just to plead guilty and receive life imprisonment.
And so was it your hope by presenting this theory of the defense, putting the state on notice that, hey, we're going to blame the state of Florida and blame the system for Cherrich's death, an effort to try to convince the state of Florida to potentially allow him to have a life sentence.
Yes.
So unlike in some other circumstances where sometimes mitigation or the theory of the defense is not known to the state until you begin the penalty phase, you were open and straightforward with this theory.
Yes.
Put the state on notice.
Yes.
To the point that during the course of the penalty phase, after the state concluded its portion of evidence, I asked the court to conduct a colloquy with the defendant, putting the court and everybody on notice that there is the potential that evidence that it's going to be presented is going to be viewed in a very unfavorable light to the defendant.
Yes.
In essence, that there would be testimony that the state of Florida could not introduce, but that the defense is choosing to introduce, that is going to bring out the fact that he was a sexually violent predator, that he had been Jimmy Riced in the past, and he had an extensive criminal history.
Yes.
And you had had previous discussions about that theory of defense and that strategy with Mr. Smith.
Yes.
And so when that colloquy took place with the court, he had had ample opportunity to understand the strategy and accept that strategy.
Yes.
And when the court conducted that colloquy, after Mr. Smith was placed under oath, he accepted that and affirmed that that was his strategy and he was aware of what was going to take place.
Yes.
And he acknowledged that that's what he wanted to have happen in the penalty phase.
Yes.
You had mentioned that you didn't want to utilize Dr. Butler in a psychological field because Dr. Butler had had extensive conversations in regards to Mr. Smith's background and history with the defendant, correct?
Correct.
And in fact, you were made aware of, and the state is now aware of because of redactions, that there were even conversations about other crimes or other bad acts that the state may not have even been aware of, correct?
Correct.
And that had Dr. Butler been listed as a psychological witness and we were able to explore those backgrounds in interviews with the defendant, that that may have subjected those statements being disclosed to the state of Florida.
Yes.
On top of that, she's not licensed in the state of Florida to practice psychology, is she?
Correct. And she doesn't forensically evaluate people.
She's an academic.
Correct.
And in fact, she primarily testifies across the state as a mitigation historian, correct?
Correct.
Where she does exactly what she did in this case, where she sort of interviews people who come into contact with the defendant in the defendant's life and then gives a global impression of the defendant.
Correct. I mean, sincerely, it was never a consideration to have Dr. Butler testify in an expert capacity. It just was never even entered our minds as a possibility.
At any point in time during the course of the trials, did Mr. Smith ever second-guess his strategy?
No.
And in fact, Mr. Smith repeatedly expressed his appreciation for the work that you and Mr. Fletcher did during the course of this trial.
I honestly don't remember. I don't remember him saying anything negative. I don't remember any kind of questions. I do remember a heartfelt thank you at the conclusion of the trial.
Well, and let's be clear, even beyond the trial, Mr. Smith's kept in touch with you.
He has.
He sent you Christmas cards.
He has.
He's even asked for your assistance in obtaining legal assistance in another field and recommending somebody to assist his mother in other legal ventures.
Yes.
So clearly, based upon those representations, he trusted your opinion.
I believe so.
And repeatedly in these communications cards that you received over the years, he was very thankful and appreciative for the efforts that you and Mr. Fletcher did for him.
He was.
At any point in time, Prior to the filing of this motion, did he ever second guess your work in this case or your strategy in this case?
No.
Thank you. Are there any further questions?
Thank you. Further?
Yes, Your Honor.
So you had created a list of 100 or more mitigators that you believed Mr. Smith had.
Yes, we all worked on them, but Dr. Butler actually was the original drafter.
And you agreed with her assessment and the list.
Oh, yes, I mean, she did an outstanding job of trying to enunciate everything, yes.
And yet you led your penalty phase presentation with someone who disputed all of it, who disagreed with every mitigator. Is that right?
Are you
Dr.
speaking of
Holmes?
Dr. Holmes?
Yes, Dr. Holmes said she didn't find anything mitigating for Mr. Smith, right?
I understand that was her testimony, yes.
Yeah. Of the 100 or more things that you thought were mitigating.
Yes.
She diagnosed him with a number of mental health conditions, none of which were voluntary, that she acknowledged that he had, but because they compelled him to commit crimes, to do bad things, she didn't find them mitigating. And you accepted that?
I'm sorry, is there a question?
Is it true that Dr. Holmes diagnosed him with a number of involuntary mental health conditions?
And can you be more specific? I just don't have a memory and I don't want to be inaccurate.
Pedophilia,
Yes,
borderline personality disorder,
yes,
antisocial personality disorder.
yes,
All of these are in the DSM, aren't they?
yes,
She diagnosed him with them.
yes.
You didn't question her about why she didn't find any of those mental health conditions mitigators?
You mean in terms of her answer to the question, I don't find any of this mitigating?
Right.
I didn't put that word in her mouth. Is that would I have loved her to use a different phrase? Certainly.
Did
Was
you
I
ask her to
concerned?
consider using
Was
a
I,
different
was
phrase?
was I concerned at the time? Sincerely, no, because of the overall presentation.
So her presentation disputed everything else that you had to present. All of the other doctors, all of the other imaging studies, everything. But you thought that her testimony was so important that it overrode all that.
Yes.
And your theme, or what you were trying to convey to the jury, was that Mr. Smith shouldn't bear full responsibility because of the state attorney's screws.
To me, it was a little bit more nuanced, and I certainly recognize there are many that could second guess me and say, I don't agree with your strategy. But the ultimate strategy in my mind was trying to tap into those jurors that are very reluctant to impose the death penalty, that recognize that there are situations where the death penalty must be imposed. For me, I was trying to give them a reason to hang their hat on of why not to give the death penalty. Here's somebody that should have been institutionalized. He should have already been institutionalized. That's what his mental health requires. That's what his addiction requires. And the state of Florida did not do that. Put him back out on the streets. So now why is the state of Florida asking you, good people, to execute another human being when he should have just been institutionalized?
That sounds like a compelling argument. Why didn't you make it to the jury?
Well, and I don't know how many times I can say it. There's sincerely never been a trial in my entire life, from county court all the way to felony court, that you don't sit down and wish you could articulate something slightly better or more thoroughly. I do the best I can, sir.
Or at the end, or in the middle. Wouldn't that be a good idea?
Why didn't I wear red today? I mean,
Okay. You were aware that Dr. Holmes in a deposition said, when she was asked about examples of mitigators, said something like sexual abuse, childhood sexual abuse. You were also aware that Dr. Butler had compiled a timeline and indicated that Mr. Smith had been a victim of childhood sexual abuse. Did you not address that with Dr. Holmes?
If you want to point me to the transcript, if I didn't ask it, I didn't ask it, sir.
Okay. Well, no, you didn't.
Okay.
Okay. And you also had concerns about Dr. Butler not being licensed, but of course you're aware that in Florida, researchers like Dr. Butler don't qualify for a license. But that doesn't make them not psychologists, right?
No, certainly. It was just never a consideration in this case. We sincerely never, ever considered using Dr. Butler as an expert witness. It was never discussed, it was never thought about. And even in hindsight, I do not think it would have been beneficial to the case.
Okay. Even though her particular area of specialty is historical information.
Certainly, and that's what we called her for.
And that's what this issue regarding the Jimmy Rice non-placement in 1999-2000, that was historical information, wasn't it?
Yes.
And you indicated that Mr. Smith acquiesced to your defense plans, did disagree.
No, definitely did not
But
disagree.
obviously you're aware Mr. Smith isn't a lawyer and doesn't have a great deal of education.
No, agreed. He does not have a lot of formal education, but he was very opinionated about his defense. And the one phrase I will keep coming back to because I have such a distinct memory of it is explaining to Mr. Smith that he was the captain of his own ship. There were many, many times he somewhat put us on notice. I'm not sure who I'm going to let you call, because I had supplied to him the case law and familiarized myself with it, that he had the absolute opportunity, if he wished, to waive all mitigation. And there were discussions about that. And these were definitely things that he felt were important at different times. Some I was in agreement with, some I was not. Ms. Periwinkle, I was not in agreement with the strategy he wanted me to employ. Because, although it was the guilt phase, everything was anchored towards the penalty phase. I certainly took the attitude in my discussions with Mr. Smith is that he controlled everything. It wasn't, I told him there are things I need to do as your lawyer that you don't really have a say over in terms of my investigation, but my presentation, you are the captain. You tell me what to do.
I don't have anything further.
Anything further, Mr. Field?
Excuse me,
I'm sorry.
So when Dr. Holmes testified that, in her opinion, Mr. Smith didn't have any organic brain damage, was she qualified as a psychiatrist or as a psychologist to render that opinion?
Probably not.
Did you object to her rendering that opinion?
I think he would tell me if I had.
Right, you're right. You also indicated that on redirect examination, you had the opportunity that Dr. Holmes was asked about her definition of mitigation, and she gave as examples being raped as a child. So you had an opportunity to ask her about the situation of being raped in jail, being molested as an 8-year-old, but you didn't do that, did you?
I imagine you would tell me if I had.
You're right.
Mr. Khalil?
Thank you, Aaron. But you didn't need to ask Dr. Holmes about that because other witnesses testified to that, correct?
Yes, I don't have a specific memory of thinking to myself whether I should or shouldn't. The benefit of hindsight is I'm sure where my mind immediately goes to is I don't think Mr. Smith ever felt comfortable talking personally to Dr. Holmes about that. And so I didn't want to highlight that that may have been information he chose to give some people and not other people.
Okay. And specifically, you did call Dr. Butler to the witness stand during penalty phase.
Yes,
And in reviewing your defense file, you actually remembered, based upon the style and everything, that Dr. Butler actually drafted all of her questions and then also supplied the answers that she would provide for her direct examination, correct?
yes. Dr. Butler has a specific way of beginning all of her documents. She uses a certain font and a certain numbering style. She uses Q1, Q2, and I've just become familiar with it because I've worked with her on a number of cases.
Okay. Oh, because even after Mr. Smith, she's continued to work with you in mitigation cases.
We currently have a pending death penalty case here in Duval County where she's my mitigation specialist, yes.
Okay.
As well as we just finished one in August.
So you called her to the witness stand, and she actually drafted not only the questions, but the anticipated responses to her entire testimony and provided that to you.
Yes.
Okay, thank you. I don't have further questions.
Anything further?
Nothing.
Ms. Schlatt, please excuse.
Yes, sir.
Thank you for your time today, we appreciate it.
Really nice to see you.
We'll take a break for lunch. Is 45 minutes enough for everybody, or do you need an hour?
Your Honor, the bailiff mentioned jurors are here today, and it might be a long line in the cafeteria.
Oh, I don't know. Are you asking for it to be an hour?
I am.
Okay. So it's 12:52, so we'll come back at 1:52. But can you give me an idea of where we're headed next as far as time?
I have 3 claims to talk to Mr. Fletcher about. I anticipate an hour, hour and a half tops.
Who's your next witness?
He's the next witness, and the one after that is Dr. Butler, and that shouldn't be more than half an hour, 45 minutes for that.
We'll have to see, Your Honor, based on how long it takes to handle Mr. Fletcher's testimony. Just based upon my review, I might have a little while with Dr. Butler.
Yeah, we might have to wait on Dr. Butler till tomorrow. It just depends. We'll come back at 1:52. We'll see where we're at after Mr. Fletcher's testimony. If it's, like I told y'all, if it's 3:30 or 4 or something like that, we probably won't
guess it was for the batteries.
Yeah, she just has a different
Oh yeah, yeah. So her camera batteries are cracked.
Yeah, I have a lot of batteries.
Oh, well, then we got it. There you go. Plug it. Should be good. Their cortex picking up your visual instead of actions.
And I'll ask them about that.
Yeah, yeah.
They don't have like a plug-in box, or is it not?
That I don't know how they're getting it, but they are getting it. It's the shop up on all three DLs right now. So everybody has it.
No, I mean for audio.
Oh no.
Like a box.
No, they don't do it. No. They'll yeah, they'll set it up there for you. Once the bailiff comes in. Also, what's his name is here? Christian's here. Then the other guy, Eric, is that his name? The short one? Yeah, well, Check, 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 check. 1, 2, 5, 4, 3, 10, 9, 8, 7. Everybody's good? 1, 2, check, check.
You can put it on the witness stand, it'd be great, but if he doesn't, he doesn't.
Oh, yeah, I know. Is it the guy over there?
Yeah. Go on, man.
Plus, I can keep somewhat track of.
Where would you like? I think we had this one right here. Thank you.
Oh, yeah. Michael said you guys were in the cafe downstairs.
The only regret is last night was the Bucks game. Cases wanted to kidnap.
But you needed to celebrate the Bucks victory last
I
night.
know, it was such a good game, but I was like, okay, I'm here.
Not be able to get Zoom. I won't be able to get Zoom because she didn't bring her,
That's fine.
she has to do the host.
That's fine.
If we just go on the news live, live stream. Yes, ma'am. Hey. Let's go on. You have answered my, and that possibly, but the other people I was talking about, they want, they just didn't pass it. I didn't have a computer, so I couldn't use. Okay. You said 152?
And you don't have to Fletcher?
No.
No. I got stuff on Fletcher, claims 1, 2, and 5. Henry doesn't have anything on 3 and 4. So, you still want to break it the way we did for Julie, or just I do all of it and then you do?
It sounds like it's gonna be shorter than Julie's anyway, so why don't we just plow through it and we'll address it as needed that way.
Okay.
That way, just, when you started switching back and forth, it's just easier for me.
Yeah, that makes sense.
I'm very simpleton when it comes to that.
And
I think it's
I'm
better
sure
for the
Judge
record.
appreciates that too, yeah.
Yeah.
You know, our issues will be all kind of like,
time.
Chuck and I coached with and against each other on many occasions.
You got a jacket, huh? That's nothing. Throw a jacket in, see.
And boots, I changed completely.
They're on the same thing.
It's very uncomfortable, you too.
Yeah.
Is it dropping out there?
No, it's in here, that's the problem. I'm freezing up.
Maybe I was there was. May have been down.
I am.
I may have coached against you or definitely coached against you. You're right.
You were where? I'm sorry. Okay.
This is.
Yeah, I guess. That's cool.
You're
session. Everybody's back in session.
I've done this a while, I forgot. Out here. Okay, we're ready to proceed, I think. Is everybody else ready?
Yes, Your Honor, the state's ready to proceed.
Okay, Mr. Smith and everyone else is back in the courtroom after the lunch break, and you may call your next witness.
Thank you. Chuck Fletcher.
Mr. Chuck Fletcher? Good afternoon, Mr. Fletcher. Let me swear you in, please.
Good afternoon, Judge.
Do you solemnly swear or affirm you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. If you'll have a seat over here.
Sir, please state your name.
William Charles Fletcher.
Okay. And you go by Chuck normally?
Yes.
Okay. Didn't want to be too familiar, sorry. And how are you employed?
I'm an attorney and I work for myself.
Okay. And how many years have you been practicing?
I think 26 and a half at this point.
And what type of practice do you have?
Pretty much exclusively criminal defense.
And approximately how many criminal jury trials have you had?
I would guess I'm over 140, but I don't know the exact number.
And how many approximately capital trials have you had?
Between 10 and 15.
And do you recall how many active capital cases you were working on at the time you went to trial with Mr. Smith?
I don't.
To the best of your recollection, had you ever had any prior dealings with Mr. Smith prior to this case?
I did. First time I ever met Mr. Smith was when I was appointed representative.
Approximately how many hours did you spend on the Smith case?
I do not remember. I have not looked at the billing, but it was, if I remember right, we represented him for about a year and a half, 2 years. So quite a bit.
Okay. And how many times approximately did you meet with him? Do you recall?
I don't recall. A bunch of times.
You were working with Julia Schlax on that case. What was the division of labor in it?
I think I was appointed lead counsel. She was appointed mitigation, but we sort of, Julia and I get along really well. We just kind of split things.
Okay.
So we just pick witnesses and that sort of thing.
And as far as jury selection, same thing?
I believe so.
It looked like during your portion of the jury selection, you primarily focused on the information on the first 2 pages of the jury questionnaire, biographical information, employment, things like that. Was that an intentional thing? Is that what your role was?
I tend to do guilt phase issues, and she tends to focus on the mitigation issues.
Okay. Do you recall having read through the juror questionnaires for the first 100, the group of the first 100?
I remember we had piles of them, yes.
Okay. And do you remember going through them all?
I remember looking at them, yes.
Okay. In front of you is what's been marked Defense Exhibit 1. Could you identify that, please, without using anyone's name?
It says Defendant's Exhibit 1, and it appears to be a juror questionnaire.
And that is for juror number?
13.
Okay. Do you specifically recall having gone through that one previously?
I've seen it since. I don't recall it at the time.
Okay.
I mean, sitting here, I don't recall it, but since the litigation has started, I've looked at it.
Okay. And that's probably the first time you looked at it since the the case
Yes.
originally?
Yes.
Okay. Did you notice anything unusual about Juror 13's questionnaire?
As it was re-brought to my attention, so to speak, question 5 on the back, where the prospective juror checked no and then crossed it out and checked yes, and then initialed it.
And which question was that?
It appears to be question 5 on the 3rd page.
And that's regarding,
Essentially, it's putting aside anything you have heard about the case and render a verdict based only on the evidence and law presented during the trial.
and if a person had checked no on that and left it as no, would you have tried to strike that person for cause?
I would have asked that person about that, yes.
Okay. Did it, to your recollection, did it raise any red flags to you when you saw that at the time?
To my recollection, no.
Would you agree that somebody who checked no and then crossed it out and checked yes could have multiple reasons for doing so?
Yes.
One of them being just a scrivener's error?
Yes.
Would you agree that one of them would be maybe a person changed their mind and decided they could set aside preconceived opinions and listen to the evidence?
That's certainly a possibility, yes.
Would you also agree that it's possible that a person could decide or realize that if they left that answer as no, they probably would get picked for the jury?
I think a juror might come to the conclusion that if I left it at no, that people would think I was a bad person for not following the system or agreeing to follow the system.
Okay.
I don't know that anyone wants to be on one of these juries.
Nobody appeared to be clamoring to get onto the jury?
Not really.
Okay. Would you agree that it would be important to question somebody about that to find out whether it was simply a mistake or something else?
Not really. The person, it looks like a scrivener's error, and I've talked to you about this before. I sometimes fill out plea agreements and I sign where the defendant is supposed to sign. Even though it says defendant and it says counsel, I still make the mistake. That's what that looks like to me. This person caught that error on their own and initialed it. It just didn't ring a bell for me.
Okay. Regarding the Colorado method, are you familiar with that?
Yes.
And that is a method of jury selection in capital cases, correct?
Yes.
And how much familiarity had you had with it in 2018 when this case went to trial?
I'm sure it was talked about at various death penalty seminars, and I've read about it. I think we incorporated what we thought we liked into our jury selection in this case.
And would you agree that it's a method that's most effectively used in cases where there's not much of a question of guilt?
I honestly don't really agree with that. I mean, I don't know why somebody chose to call it the Colorado method and then sort of impose it on everyone that does death penalty litigation. I like to just pick a jury the way I like to pick a jury. I think it has some good attributes, and we tried to incorporate those, but I had a jury trial 6 weeks ago, and we took the first 6 after striking 2 for cause, and it resulted in a not guilty. So I can now say that's the best way to pick a jury if I want to, right? But might not be.
Sure. Would you agree, though, that it would probably be a good idea to have some kind of systematic method of educating the jurors as to their role in penalty phase?
When you say systematic, what do you mean?
I mean, actually questioning individual jurors. Were you aware that you are not required to have a unanimous verdict?
Sure.
On penalty phase?
Sure.
Okay. Are you aware that you're under no obligation to explain your individual decision to anyone, including other jurors?
Sure.
So there are portions of the Colorado method educational part that you agree with?
Well, I didn't realize that those particular questions were from the Colorado method. I thought that was the kind of stuff you'd ask anyway.
Oh, okay. Another part of it is kind of insulating jurors who would be more prone to consider life without parole, no matter how heinous the circumstances are, against possible cause challenge. Would you agree that that would be a good thing to do?
To try to insulate them?
Yes.
Sure.
And also try to get people who are most likely to be automatic or near automatic death penalty votes, to get them to say things that will ensure that they're going to get struck for cause.
Sure.
And at the time of Mr. Smith's trial in 2018, to the best of your recollection, had you ever used the Colorado method in any of your cases?
I don't think I had. I mean, I've certainly talked about tough facts in jury selection, and that's part of the Colorado method, but I don't know that I knew that I was doing the Colorado method.
Okay.
So,
And I take it then you didn't actually discuss it with your co-counsel, with Mr. Smith, correct?
well, I think we talked about Colorado method. So I think we did.
Okay. What strategies did you use or do you typically use to try and find jurors that are favorable to your position or exclude unfavorable ones?
It's just we ask lots of questions. Kind of the standard thing we do in any trial. I don't know that I treated it any more special.
Okay. And I also want to ask you a few questions about another matter. Penalty phase was primarily Ms. Schlax's responsibility, correct?
Yes, I did a few of the witnesses, but that was her primary responsibility. I guess you could say that.
Okay. And you did, however, do the opening statement?
Yes.
Okay. And you were aware that your theory of defense, in part, was to try and assign responsibility or blame to the state attorney's office and the Jimmy Rice system for not involuntarily committing Mr. Smith in 1999-2000 when they had the chance.
I think we were trying to say that this happened because they didn't keep him in jail or in the Jerry Rice system or something like that, so yes.
Okay. But you were also aware that you were planning to call a neurologist, a radiologist, a pharmacologist, various other experts to testify about Mr. Smith's brain damage, correct?
We were trying to put on evidence that would give us the opportunity to argue that he was very sick, drug addicted, couldn't control his impulses, that sort of thing, yes.
Okay. So it was important to you to point out to the jury, since it was the first chance that they had to, for you to address what to look for in the penalty phase presentation. It was important to you to show how much warning the state attorney and the Jimmy Rice people, HRS, had about Mr. Smith and to lay the blame partly at their feet, right?
Well, I don't know that they had all the information that we had. In other words, we had doctors look at him. He had a brain scan done and the imaging, and if I remember right, it's been a while, but he had a sort of a dark matter or a gray matter. But I don't think the state had that prior to him committing the crime and us doing those things.
But you were aware that he had been considered for involuntary commitment?
Yes.
And were you aware that 2 of the 3 evaluators had opined that he qualified for involuntary commitment?
Sitting here, I don't remember, but I just remember something went wrong in that case. Somebody that was representing him got him just a super good deal and got him out. mind, but I can't remember.
During your opening statement, the only thing that you stated about the matter was noting that Mr. Smith was in custody in 1999, they did evaluations, and I'll quote, "He met the criteria for a violent sexual predator and is likely to reoffend, but the petition that got him there illegally a couple of years later was dismissed. He fell through the cracks and he's out again."
Okay.
Do you recall that?
Somewhat.
And that was the only time you addressed that whole thing?
Well, it's an opening statement. I can't argue, right?
Right.
That would be for the closing argument.
But do you think it would be important to emphasize to the jury, you know, this is one of our defense positions?
Well, you just read a statement where I seem to have done that he had big issues, he was evaluated, and I didn't say drop the ball, but I said he fell through the cracks, if I remember my quote.
Right.
To me, that's me addressing it.
Okay. And that was the only time you addressed it in your multi-page opening statement?
I try not to repeat myself over and over. I'm short and to the point. That's my strategy. I mean, that's my style.
If I could have one more.
Sure.
Nothing further.
Mr. Flail?
Thank you, Your Honor. Good afternoon, Mr. Fletcher.
Good afternoon.
During the course of jury selection, this was somewhat unique in the sense that we employed the use of a jury questionnaire in this case. Is that accurate?
Yes.
And the jury questionnaire, which was discussed, and you had reviewed juror number 13's questionnaire, asked a number of questions highlighting publicity to the case, knowledge of information, but also discussed death penalty issues, correct?
Yes.
And specifically on juror number 13's questionnaire, you thought and interpreted how it was written when it came to question 5 on page 3 as a Scribner's error. Is that accurate?
Yes.
During the individual questioning of juror number 13 and the questioning as a group, did you hear or observe anything that led you to believe anything different than it was a Scribner's error?
No. If I recall, she was on the jury, so we must have liked something about her.
And in fact, juror number 13 indicated she was a black female, correct?
Yes.
That her husband worked for the Department of Juvenile Justice as a teacher, correct?
Yes.
That when asked the question where she fell on the scale of 1 to 5 when it came to the death penalty, she indicated she was a 3, correct?
Yes.
And her phrase that she used, or word that she used to describe her personal feelings about the death penalty was that it's unfortunate but needed at times.
Yes.
Is that accurate?
Correct.
Additionally, she indicated that her father was a recovering drug addict. Is that accurate?
Yes.
Obviously, during the course of the penalty phase, you produced or presented testimony from Dr. Buffington in regards to how drug abuse, and specifically this defendant's drug abuse, affected his judgment in his actions on the day in question, correct?
Yes.
Did you feel that juror number 13's experience with a relative who had experienced drug abuse was beneficial to the defense?
Yes, I would have assumed that she would have some sympathy for what we're saying.
And the statement, unfortunate but needed at times, that again seemed to be a very defense-oriented or sympathetic viewpoint in regards to the death penalty.
To me, she was being honest. So yes.
And in fact, the fact that her husband worked within the criminal justice system in a teaching capacity, you thought that would also be beneficial to the defense based upon how it may make her more empathetic to the defendant's
Yes.
Treatment and rehabilitation.
Yes.
When you review through her answers to the questions posed during jury selection,
Both then and as you sit here today, do you find her to be a defense-oriented juror?
Based on her background, I thought she was probably more helpful than harmful. Yes, a defense-oriented juror.
Did you have those discussions with Ms. Schlax during the course of jury selection?
I do not have a specific memory of discussing that, but that is the kind of thing that we do discuss after we question, so yes.
And there was nothing indicated in any of your notes or counsel's notes that would have indicated that you felt that this juror would have been a bad juror for the state, or for the defense, rather?
Correct.
And the defense team, along with the defendant and Ms. Butler, who was acting as your jury consultant, all agreed to keep this particular juror on the panel?
We kept that juror, yes.
Because you believe she would be a potentially good juror for the defense in this case?
Yes.
And when given the opportunity to ask for more peremptory strikes, you declined, or the defense declined, it didn't seek any more peremptory strikes?
That's correct.
You were satisfied with your jury in this particular case?
We liked our jury, and my memory is that Mr. Smith liked the jury. We liked the jury.
Let's talk just briefly about the Colorado method. We did utilize the juror questionnaires in this particular case, and one of the questions related to the death penalty that was vetted out during individual voir dire was whether or not a juror either could never impose the death penalty, and they were asked to disclose that to us, or would always impose the death penalty, sort of the diametric opposite ends of the spectrum, correct?
Yes.
And individual voir dire was lengthy, and any individual who either indicated they could never impose the death penalty based upon their beliefs or religion or whatever it is, they were not allowed to proceed to the next phase of jury selection, correct?
That's correct.
And the same is true with individuals who felt that they would always impose the death penalty under the circumstances that they were presented with. And if an individual indicated that they would always impose the death penalty and they could not be open to a life sentence, they were also excluded as to proceeding to the next phase of jury selection.
Correct.
That's really part of the Colorado method, isn't it?
Yes.
Also part of the Colorado method is using these numerical scales to determine where the jurors who are being questioned fall in that spectrum. Is that accurate?
Yes.
It's safe to say that my questioning during voir dire sort of headed that off at the pass because I asked those questions during jury selection, correct?
Yes, and as far as the numerical system, we've been doing that for years, long before I ever heard of the Colorado method. So.
Yeah, and in fact, that's been something very commonly used in this jurisdiction ever since we've been trying capital cases in our careers, correct?
My first one was with you and Ms. Nelson many, many years ago, and I'm sure we used it. So yes, from day one.
Okay. There are also aspects of the Colorado method that, based upon the case law in the state of Florida, are not appropriate, correct?
Yes.
It's inappropriate in the state of Florida to ask jurors to prejudge the facts and circumstances of any case.
That's correct.
And oftentimes when defense counsel try to explore in that capacity and pose hypotheticals to prejudge a case, they're met with objections, correct?
Yes, and I think the judges usually say, don't try your case in jury selection, so.
And in fact, I lodged similar objections that were sustained in this particular case.
Yes.
And during the course of jury selection, Ms. Schlax even mounted a picture of the deceased victim and showed that to the jury during the course of jury selection.
She did.
Okay. Trying to emphasize that this was in fact the death of a child, the rape of a child, things of that nature.
Putting that right out there, yes. And an adorable little girl, you know, that's sad.
So all of those things in sort of preconditioning the jury to these type of facts, overwhelming evidence cases, that was all vetted out. While maybe not in name to the Colorado method, you and Ms. Schlax incorporated aspects of that throughout the course of your jury selection.
That's correct.
There wasn't what people refer to as traditional mitigation in Mr. Smith's case, was there? Or at least not a substantial amount of traditional mitigation. People who are willing to come forward and say, hey, this is a great guy, things of that nature.
That's true.
In fact, you and Ms. Schlax had extreme difficulty in finding anybody who was willing to testify on Mr. Smith's behalf in this case.
Correct.
To the point where the traditional family history and things of that nature were vetted out through Dr. Butler, the mitigation specialist in this case.
Correct.
Because Mr. Smith didn't want his mom testifying in this case.
Correct.
And friends, neighbors, co-workers, they just outright refused to testify in this case.
Correct.
And the mitigation that was present, you and Ms. Schlax called multiple experts to vet out, correct?
Correct.
You called neurologists to the witness stand.
We did.
You called a pharmacologist, Dr. Buffington, to talk about how the narcotics affected his judgment and his behaviors.
We did.
But also you called Michael Bosson, a practicing attorney, as a legal expert in this case, correct?
I didn't, but Julie did put him on, that's correct.
Okay, and there was a discussion about how that was going to be utilized to vet out the lengthy and extensive criminal history that Mr. Smith had prior to this offense.
Correct.
And you also had multiple discussions in regards to Dr. Holmes' testimony, correct?
Yes.
Both as a trial team, but also with Mr. Smith.
Yes.
And Dr. Holmes' testimony was no surprise to the defense team or Mr. Smith when she testified on the witness stand.
No.
And in fact, Dr. Holmes' testimony was a strategic move to discuss the fact that he was a sexually violent predator, but the state did not commit him when they had the opportunity to do so.
Correct.
And in fact, in her testimony, it was elicited that she actually even believed it might have been a typographical error on the report where they said not to commit Mr. Smith during the Jimmy Rice proceedings.
Correct.
Because the content of the report seemed to indicate that he should be committed.
Yes.
And it was your strategy and Ms. Schlax's strategy, which was adopted by this defendant, that you were, in essence, claiming that, using your words, Mr. Smith had fallen through the cracks of the system. And it's because of that failure that he was even on the streets capable of committing this crime.
Correct.
To the point where you even came to the state attorney's office as a defense team and gave us a heads up that you were going through that strategy in efforts to maybe convince us to seek a life sentence versus proceeding with death, correct?
That's correct.
And that defense strategy was basically almost a Hail Mary because you felt that that was really your only chance of maybe convincing at least one juror that you could seek, you should receive a life sentence versus the death penalty.
Yes.
So knowing that going into the trial and advising the state, even before you called your first witness in the penalty phase, I asked the court to conduct a colloquy and question the defendant himself that this was his strategy and he agreed with it.
That's correct.
And prior to that colloquy, had you and Ms. Schlax had multiple conversations with the defendant about that trial strategy?
Yes. He knew exactly what we were doing.
And did he endorse and agree with that trial
He was
strategy?
fine with it, yes.
And it was only after his agreement under oath in open court that we then proceeded with the defense presentation of their case in penalty phase.
Yes.
Thank you, sir. I don't have any further questions.
Anything further?
Yes, Your Honor. Mr. Fletcher, you indicated that you assumed that Juror 13's marking both answers on question 5 was a Scrivener's error, correct?
When I look at it, and remember, when I look at it today, I would still say the person checked the wrong box and got rid of one of them, checked the correct box or the one that was her answer, and then initialed it.
Would you agree, though, that it's possible that she had checked the box that she felt initially and then changed her mind for some reason, crossed it out for that?
That's possible.
Would it be a good idea for you to find out whether that was the case?
at the time, it looked like a scrivener's error,
So you
a
never
mistake
asked.
to me. It just looked like a simple mistake. And she
So-
came across as a decent juror, and we went with it.
So you never asked.
I don't believe we did ask.
Okay. And you assumed that she would be sympathetic to drug addiction issues because of her family connection.
Yes.
Did you ask her about that?
No, she said that.
She said that she had
A family member,
who
a
was
very close family,
had been
it was her
addicted,
father,
yeah.
close family member that had a drug addiction.
Did you ask whether or not she was sympathetic for that reason, or did she
No, we
hate
did not.
drug
We didn't
addicts
follow up
because
on
of-
that.
Okay. Mr. Khalil also talked to you about certain objections that might be made to people using something like the Colorado method.
Well, actually, let me finish my last answer.
Okay.
There are times in jury selection when a person says something, I feel like if we follow up on it, then maybe the state's going to use that as their reason to strike them. So if somebody implies to me, or I get that, I infer based on what they say, that they might be sympathetic to a person with a drug addiction because they have a person like that in their family, it's like I don't want to call attention to it so that Mr. Khalil then uses that as a reason to strike that person. So I did not, I don't think we followed up on it.
Okay. Regarding the Colorado method question, Mr. Khalil told you that if someone were asked to commit to a particular verdict, that would be improper, correct?
Well, if they're going to say, I'll never find somebody eligible for the death penalty, I assume that person will be stricken by the state.
Right.
And if they say, I will always give life, I'm sorry, be stricken by the defense, if they say they'll always give life, then the state's going to strike that person.
Were you aware, though, that the Colorado method doesn't ask them to commit to a particular verdict, but rather just to commit to consider all options?
To me, it's the same thing. Because if they say I would only consider death,
I'm sorry, I'm having a hard time seeing how that's the same thing.
ask a question again. Let me think about it for a second.
Do you think that, as the Colorado method it recommends, asking jurors to commit not to a particular verdict, but to consider all options, do you think that's objectionable?
I think it's objectionable
Yeah.
to ask them whether or not they would consider all the options.
Yes.
No.
Okay, well, that's what the Colorado method advises doing. That's not objectionable in your opinion, right?
I got to stress this with you. Nobody says you have to use the Colorado method to pick a jury, right?
Right.
Sometimes you just get up and you try to be a really likable person, and you hope that one person on the jury likes you enough not to sentence your client to death. So I don't sit here and think that the Colorado method is some gold standard. I understand that people employ that method, and then at the end of some of their trials, they get life sentences, but I don't know that that's the reason they get life sentences. I've done 100 and something jury selections, and it's back and forth, and like I said, I did the first 6 the other day. So now I can go around and say, you got to do it this way, right?
Well, based on one, I don't know, but based on 30 years, different story, right?
We just do our own thing in jury selection, put it that way.
Okay.
We incorporated some of their ideas from the Colorado method.
Okay. Regarding the penalty phase matters that Mr. Khalil was talking to you about, you would plan to call, and you did call, a number of experts regarding the extent and types of brain damage and psychological issues that Mr. Smith suffered, right?
Yes.
Were you aware that the first witness you called opined that, in her opinion, there was no mitigation, discounting all of the experts that you called later?
That there was no mitigation?
Right.
To me, when someone says there's no mitigation, it means there's no family coming forward to say he's such a great person, that sort of thing. To me, mental health evidence is different from that kind of mitigation. So if you're referring to Dr. Holmes, I guess I was aware of that.
Okay. And she specifically said, in her opinion, having diagnosed him with a number of mental health conditions, that he had no mitigation. aware of that?
Yes, but we had witnesses that were looking at other aspects of him. I mean, she doesn't know how to interpret a brain scan to see that there's brain damage.
So
Or that there's dark
it would have been
areas.
improper for her to have opined on whether or not he had organic brain damage, which she did also.
I don't remember that.
No. But if she did that, it would have been objectionable. It should have been objected to, right?
Was she doing it on, I didn't call that, that wasn't my witness. Did she do it on direct examination?
No, she did on cross.
I don't know if it's an area that she's an expert in, so maybe I would have objected it.
Okay. But you didn't do the direct on, or you didn't have responsibility to take care of the cross either, right?
No.
Okay.
And I had the witnesses that were the experts in brain damage, so.
Okay. Could I have a moment, Your Honor?
Sure.
Anything else? Nothing further.
Mr. Cleo, anything further?
Nothing further with Mr. Fletcher.
May you be excused?
Yes, Your
You may.
Thank you, Mr. Fletcher. We appreciate your time.
Thank you, Judge. It was good to see you.
It's good to see you too. Before we proceed, there's a couple things. They're moving us tomorrow to courtroom 406. If you could let, please, Mr. Skinner know that for the one case that he has on the calendar tomorrow.
I will.
We'll still start at the same time, 10 o'clock, but we'll be in 406. The media requested it because it's set up for them to be able to use the pool camera and all that. So it's available, so we're going to move to that courtroom. The next witness, can you give me some time frame?
Dr. Butler, direct is gonna be probably a half hour, no more than that.
That'd be fine. I mean, once we get through with the direct, Your Honor, I have a cross prepared. If it's only a half hour, that takes us to just after 3 o'clock. I'm very confident we can conclude our testimony by 4 o'clock now.
All right, then let's go ahead and call her. That sounds good. And maybe you'll even conclude it a little before that.
I'll work on it, Your Honor.
Okay.
We'll talk fast.
All right, Dr. Butler, please. What's Dr. Butler's first name?
Brooke.
That's right.
With an E at the end.
Good afternoon. You have a lot in your hands. I'm gonna need to swear you in when you get a chance. Do you solemnly swear or affirm you will tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, please have a seat over here, and if you want to put your stuff in a chair, your umbrella type stuff, so you don't have to deal with it in the witness chair. Thank you, Dr. Butler.
Ready? Good afternoon.
Good afternoon.
Please state your name.
My name is Brooke Butler.
And how are you employed?
I am employed as a psycholegal researcher, mitigation specialist, and litigation consultant in private practice.
Okay. And you have a doctorate in psychology, correct?
I do.
And you're not licensed in Florida, however, correct?
That's correct.
And would you explain why that is?
Yes. The state of Florida licenses 3 areas of psychology, and they're all involving the field of mental health. They're the areas of clinical, counseling, and educational psychology, and they are people who treat and evaluate patients, if you will. And so there's no licensure in my area of psychology. My background is in research, and so as a result, I'm not licensed.
But as a researcher, you deal extensively with historical psychological diagnoses, for example.
Correct.
And you can do that without necessarily having to currently diagnose or treat a patient.
Correct. My PhD is in legal psychology with a background in social psychology. So my focus since earning my PhD in 2000 has been decision making.
So if you were asked to review some prior psychological evaluations of an individual, you would be able to do that, correct?
Yes, and I do that routinely in my career.
And you're also familiar with the Jimmy Rice program, correct?
Yes.
And the criteria for it?
I'm familiar in general with the criteria for it, although I certainly wouldn't evaluate whether or not someone was appropriate.
Because that would be beyond your...
Correct,
okay.
yes.
Okay. But you certainly are aware of the criteria that are used in it.
Right, and I have had clients who've been involuntarily committed to the program.
So, given that in this case, that would be the type of evaluation and consideration that would be needed in order to testify that someone in the past could have or should have been committed to a Jimmy Rice program, that would be something that you could do without going beyond your legal qualifications, correct?
Correct. As part of a social history or a social historian or someone's biopsychosocial history, I could certainly outline their psychiatric or psychological hospitalizations, and in turn their civil commitments, and what psychologists or clinicians, what criteria they looked at to determine whether or not someone was appropriate for the program or not appropriate for the program. I certainly couldn't opine as far as whether or not I agreed or disagreed with the decision, but I could certainly recount that as part of someone's social history or as a mitigation expert, which I've done in previous cases.
And you were aware that Dr. Heather Holmes was hired in this case as well?
That is correct.
And you became aware during the course of your work on this case that Dr. Holmes had made some statements that did not help Mr. Smith's case, is that correct?
That's correct.
And what did you do when you learned about that?
I learned about the statements that, or to back up just briefly, I recommended Dr. Holmes to the case because I'd worked with her previously and I liked her work quite a bit. I knew she had a background. She was a licensed clinical and forensic psychologist. I'd worked with her on previous cases, been very happy with her work. And I knew she had a background in diagnosing and treating sex offenders. I knew she'd led treatment groups at the now defunct Brevard Correctional Institution. And she was familiar with the Jimmy Rice civil commitment program, and she also had a background in trauma, and she certainly, of course, was able to diagnose and in turn recognize mental illness. And so when I recommended her, that is why I did so. She and I had, over the course of my involvement in this case, which was from September 2014 to February 2018, she and I communicated about Mr. Smith only a handful of occasions. It was there was one phone call in the fall of 2015, and then 2 emails, again, fall of 2015, and that was it. So that was the extent of what I knew regarding her opinion about Mr. Smith and her feelings regarding, or her thoughts or opinions regarding what he was, her evaluation or assessment of when they met, and diagnoses and the like. And so I learned formally for the first time of her opinion in December of 2017 when I received her report. And then in January of 2018, she was deposed, and then I received those depositions in the deposition transcripts in February of 2018 in jury selection, in the middle of jury selection.
And was that the first time you realized that she intended to testify that despite having diagnosed Mr. Smith with a number of mental health conditions, it was of her opinion that he had no mitigation?
Correct.
Okay. And what did you do when you learned that?
I was surprised. It seemed contradictory because Dr. Holmes was an experienced expert. She was an experienced clinician, and it appeared to not be based on her evaluation, because on one hand we had her diagnosing Mr. Smith with a major mental illness, pedophilia, and recognizing that he had a long history of mental illness that had been relatively stable. Of course, when we're looking at the issue of pedophilia, and we're, in the context of the legal system, we're almost always talking about offenses committed against children, and that's a horrible thing to have to discuss, but that's the nature, unfortunately, of pedophilia in the context of the legal system. And so we knew that information was going to be brought in if we were to talk about his long history of mental illness and how sick he was, how mentally ill he was.
But pedophilia is recognized by the DSM.
Oh, right, it is. It was in the DSM, I don't know what it was at that time, 5 maybe at that time. And so I was not understanding why, on one hand, she was recognizing that he had a severe drug addiction, substance user for almost since adolescence, substance abuser and a cocaine addict, as well as the pedophilia, which are mental illness and substance abuse and addiction are very well-known mitigating factors that we see in almost every capital case. Not necessarily pedophilia, but substance abuse is almost in every one of my capital cases, and some form of mental illness as well. And then saying that there's nothing mitigating about him, I was unclear about that. That took me by surprise.
It sounds more like a moral judgment than a professional opinion, doesn't it?
It did. It sounded more like a legal argument, as opposed that in my opinion, should have been left up to the fact finder, the jury, the judge. And there were some inaccuracies in the report that I was surprised about. I know from communications with her that Mr. Smith had disclosed that he'd been sexually molested as a child by 2 boys. And that was in the report. It said that he disclosed no molestation. And that I know that she had disclosed to me, and again, these communications were by email, that he had demonstrated remorse for his offenses, and that she found that very encouraging. And I thought that that's a tremendous mitigator that we see. But it was not in her report whatsoever. If anything, she said that Mr. Smith blamed the victim, which is horrible.
And you had prepared a psychosocial timeline in this case.
Right, I had prepared the psychosocial timeline. Yep, the psychosocial timeline, which outlined his family history and incorporated his psychological history, which involved some of his legal offenses as well. And there was some information that in the report that was just incorrect, and that concerned me.
Did you ever address that with his counsel?
I addressed the lack of what I thought was an argument of lack of mitigation with the defense counsel, and the fact that I was going to be testifying as a mitigation specialist about the mitigation that was going to be present in Mr. Smith's case and the apparent contradiction that could present.
And who did you speak to specifically?
I spoke with Ms. Schlax about it.
And what was her response?
It was my understanding that Ms. Schlax felt that Dr. Holmes was the only expert who could bring in into evidence his psychological and psychiatric history as it related to Jimmy Rice and the post-sentence civil commitment. And that was one of our mitigation themes, absolutely, that he should have. He had a very long history of mental illness, very long history of offending, and the state really did miss some big signs, and he should have been at the very least monitored. And they dropped the ball, and so.
You could have testified to that, could you not?
I could have testified as far as as far as a social history regarding his psychiatric history. Yes, I could have. Now, to be fair, that was not discussed. We never talked about me taking the place of Dr. Holmes in any way or me testifying as an expert. It was always as a mitigation specialist or social historian, however you want to describe, however you'd like to describe my role.
She was aware of your educational background and
yes, she was.
And qualifications.
She was.
So if she had been looking for an alternative to Dr. Holmes who wouldn't opine that he had no mitigation, you could have been considered, right?
I could have. I don't, to be clear, I don't know about the rules of evidence and bringing things in terms of what could be brought in, but she knew that I had testified as a mitigation expert before, but I'm not considered a psychological expert when I testify at that time. It's literally about someone's biopsychosocial history, which always includes medical history, psychological history, psychiatric history, military education, all of it just runs the gamut.
But to your knowledge, there's nothing that would forbid you from being able to testify as an expert in psychology, correct?
No. I mean, I've been qualified as a mitigation expert 15 times in Florida, and have done so in circuits across the state of Florida.
And had you been asked to testify in place of Dr. Holmes, you would not have testified that Mr. Smith had no mitigation, would you?
No, that was not to be clear, no mitigation was never a mitigation theme.
Okay. And in your opinion, the conditions that Mr. Smith had been diagnosed with, they're not voluntary, are they?
It's well known that pedophilia is not a choice.
Okay. And it's not treatable?
No, it's not curable. I mean, it's managed. It's managed, and Mr. Smith had, we know historically that the best treatment or management for Mr. Smith always was confinement, and Mr. Smith had tried to, which was another one of our themes, a big theme, which was about 2 weeks before the offense, he tried to confine himself as a Baker, in terms of Baker acting himself, because he told a nurse at a hospital that he felt suicidal and homicidal, and he was kept for a very brief time, I believe, given a pamphlet, and released shortly thereafter.
And this was a couple weeks before the offense?
It was. I believe it was 2 weeks before the offense, unfortunately.
If I could have a moment.
Sure.
No further questions.
Thank you. Mr. Khalil?
Thank you, Your Honor.
Good afternoon, Dr. Holmes.
Good afternoon.
Or Dr. Butler, I apologize. Dr. Butler, I think you stated this on direct. You actually suggested to the defense team that they seek Dr. Holmes as an appointed expert in this case.
Yeah, I did, and I take full responsibility for that decision.
And you recommended that because you believed at the time that Dr. Holmes had a unique set of credentials that made her particularly well qualified for this specific case.
I thought so at the time. In my experience as well, she had been, in previous cases, really communicative with all members of the defense team. This case was different. I don't know why.
She had experience working with persons with pedophilia and sexual disorders, correct?
Yes, that was my understanding, is that she did diagnose and treat people with people who were sex offenders, and she knew pedophilia. My understanding was she knew the etiology, the symptomatology, the treatment management, relapse rate, and the effectiveness of treatment. All of this, so many things regarding this particular mental illness that Mr. Smith had been diagnosed with.
And in fact, she led treatment sessions in the Department of Corrections.
Correct, at Brevard Correctional Institution, yes.
And she had knowledge in trauma and neuropsychology.
Yes, that is correct. That was my understanding.
And she had previous experience in capital litigation all across the state of Florida.
That is correct, yes.
And she's still utilized by defense attorneys all across the state of Florida.
That is correct.
She was even recommended by the ACLU consultants, Mr. Stoll and his team, when they were seeking out potential experts in this case.
I don't know if she was recommended by them. I can't say she wasn't, but I won't dispute that she wasn't.
And basically, and you've owned this, the defense team followed your recommendations and they retained Dr. Holmes.
Yes, they did.
Now, you claim that Dr. Holmes, prior to her deposition, never disclosed her professional opinion that was detrimental to the defense.
To me, no.
Okay. Well, let's be clear. You were hired as a mitigation specialist, correct?
Correct.
You actually served at some portion as a jury selection consultant, correct?
Correct.
But you have no legal background, meaning you're not a lawyer.
I'm not an attorney, correct?
And the legal team in this particular case was Ms. Schlax and Mr. Fletcher.
Correct.
Defense counsel had a conference with Dr. Holmes on September 5th. Were you present for that conference?
I was not.
Okay, so you did not avail yourself to the discussions that they had with Dr. Holmes during that conference?
It's not that I didn't avail myself, I just didn't know about them. I would have.
So the defense team, for whatever reason, decided not to include you in that process?
For whatever reason, correct.
Okay. Were you also aware that there was follow-up conferences with Dr. Holmes on November 7th of 2017?
No.
Okay, so you weren't present for that phone conference?
No, I was not present.
You weren't present for those conversations that they had with
No, sir.
Dr. Holmes? So you weren't a party to the legal strategies that were being contemplated by Ms. Schlax or Mr. Fletcher as to why they would determine to call her as a witness?
I wasn't a party, to clarify, I wasn't a party to that phone call. I was always supportive of the legal strategy or the mitigation theme, if you will, kind of, terms are a little bit synonymous in this case, that Mr. Smith should have been confined based on his history of offenses and his propensity to reoffend. So that in and of itself was not a surprise at all.
Okay, but to be clear, you're a witness in this case. You're not part of the legal team.
I'm part of it, well, I'm a key member of the defense team, which is, you know, it's a fact investigator, at least two attorneys and mitigation specialist. It doesn't mean that, that the attorneys have to include me on every phone call or include the investigator on every phone call, but there's a defense team and kind of all four people are a part of it, so.
Well, you were part of the team, but they chose to exclude you in these discussions.
They chose to not include me in the conversation.
Okay. And clearly, you would agree that the fact that Mr. Smith was out and not Jimmy Rice during the course of his multiple encounters with the criminal justice system, that was a failure of the system.
It absolutely was.
And in fact, he's a, for lack of a better term, he's a textbook sexual predator.
That I can't opine.
And I think that's the difference, is Dr. Holmes can, because she has the expertise and training to
Sure.
apply to that.
Oh, absolutely, yes.
And I think you already said you're not a licensed psychologist in the state of Florida.
Correct.
And your primary role in this particular case was to serve as a mitigation consultant.
Correct.
The focus of your practice is actually psycholegal research.
Correct.
You don't actually examine patients,
Nope.
and you don't do evaluations to determine whether or not somebody is Jimmy Rice eligible or not.
No, sir, I never have.
And all of your experience in capital litigation has been as a defense expert. That would be accurate, correct? You've never been called by the state of Florida in any case?
Correct. No, I haven't.
You met with Mr. Smith, the defendant, for over 100 hours in preparation of this case.
Correct. We spent a lot of time together.
And without disclosing the substance of this, you relayed and had conversations with the defense team that Mr. Smith had discussions with you that may open him up to liability on other criminal actions.
Correct.
Okay. And that's a legitimate fear of the defense involving you further in testimony in this particular case, because that may in fact open the door that may subject Mr. Smith to further criminal prosecution.
Absolutely. And to add, if I may, that was one of the concerns I had about testifying. I was concerned about testifying because I knew I'd spent a lot of time with Mr. Smith. I had never testified in a penalty phase proceeding before in a capital case because I do tend to spend a lot of time with my clients and they do tend to make disclosures, and some of which can be, can make me vulnerable on cross-examination. So yes, that's fair.
Okay. And to be clear, I think clear from your notes and your discussions with defense counsel, guilt was never an issue in this case.
Oh, absolutely not.
In fact, you testified in front of the jury that we knew the defendant was never going to contest his guilt.
Correct. Mr. Smith never contested his guilt. That was never an issue. No, sir.
Okay. Just in short and summary, you believe Ms. Schlax and Mr. Fletcher made an error in calling Dr. Holmes.
I don't think that's up to me to determine.
Whether it's up to you to determine or not, is it your personal opinion that they made an error in calling Dr. Holmes to the witness stand?
Again, I don't think it's up to me to determine. I don't think it's a fair question. I remember some things a little differently in terms of how conversations transpired. It was my understanding that after a deposition, Dr. Holmes had said that she was going to said some things that made Ms. Schlax feel a little bit better about the deposition. It's my memory. I'll never remember it a different way. And when I'm referring to that, it was saying that there was nothing mitigating about Mr. Smith, because that, although that was never a strategy ever.
Well, it wasn't your strategy.
It was never a defense team strategy to say there was nothing mitigating. If it was, I would not have been on the case.
Well, and let's be clear, after the deposition, you were aware that Ms. Schlax had extensive conversations with Dr. Holmes, and she relayed to you that she is comfortable and she's eased any concerns that she had. She made the decision to call in Dr. Holmes.
Correct. She did not make it clear. She did not say that she was fine with Dr. Holmes saying that there was no mitigation in this case regarding, or nothing mitigating about Mr. Smith.
Okay.
That was not
But she made the legal decision to call
She
Dr.
made the legal
Holmes.
decision, and she's the attorney, and I respected that decision, but
You wouldn't have made that decision.
not being an attorney, it's hard for me to say. Had Dr. Holmes walked back some of the testimony that I thought she was going to regarding no mitigation, perhaps I would have. I thought that she was going to say some things regarding no mitigation, you know, in terms of her misunderstanding the definition, or I don't mean mitigation, in terms of the legal decision that the fact finder is supposed to be making. I'm saying a mitigating diagnosis that can be cured or treated, or something that, you know, is more manageable. These are just the things that I thought that perhaps Dr. Holmes was going to be saying, and that just did not happen.
Okay. Do you think the defense made an error in calling you to the witness stand?
I don't know.
Well, to be clear, at trial, you testified in front of the jury that the defendant had been committed as a sexually violent predator, correct?
I believe so. If you say that, I believe so.
You provided extensive details of the defendant's cocaine usage, correct?
Yes.
You provided details to the jury about the number of his arrests and the substance of his arrest, correct?
I believe so.
And that type of information, unless it's presented by the defense, is not typically admissible by the state in these type of proceedings, correct?
Correct. But I believe Mr. Boston had gone into great detail regarding that, and the crux of my testimony was his family background.
Well, it's not his family background that you discussed in front of the jury that he was civilly committed under the Jimmy Rice Act, is it?
No, but that had already been discussed.
But-
Had it not been, I wouldn't have, but
But-
that had been talked about.
So you reinforced that fact when you testified to it in front of the jury.
It was, again, one of our mitigation themes that he should have been committed, continued to be committed.
And in fact, you even detailed and discussed his multiple stays in Florida State Prison.
I don't recall doing that, but I'll take your word for it. Absolutely.
Well, I appreciate you taking my word for it, but I believe, and I'll try to direct you best that I can to page and line number of your deposition, of your trial testimony.
I mean, I don't have any objection to my doing so.
Okay.
I know that it was already referred to, and he'd been incarcerated. He'd been incarcerated for most of his adult life, and so that was certainly one of our themes. So.
And in fact, you actually said those exact words in front of the jury, that Mr. Smith had been incarcerated for most of his adult life, if not his entire life.
Sure.
You actually told the jury that the defendant was a mentally disordered sex offender at the age of 20.
Correct.
And you told the jury that he was designated as a sexually violent predator in 1999.
Correct.
And that the defendant was open in your discussions with you that he was in fact a sex offender.
Yes, that's something that we talked about.
Could we just, you were going to cite to the record, would you mind for?
Well, she admitted to it, so I'm just moving on.
I understand, but for our purposes and for redirect, I'd like to know what you were going to do. If it's not too difficult.
Well, it starts at, this entire discussion begins on page 1955 of the record, line 20, and goes all the way through 1970 and 1971. So, moving back to the line of questioning that I had, quoting you specifically in your testimony to the jury, he testified that he had the urge to intensely hurt somebody. Correct?
Correct.
All of that sounds really damning to the defendant.
Couched in well, I believe all of it had been previously discussed and would not have been a surprise to jurors first. And second, in my opinion, the background of discussing his offenses was not to highlight his dangerousness or his, propensity for violence. It was his severe mental illness that had been pervasive since the age of 20, 21.
That was your opinion, but not necessarily the legal opinions of the lawyers handling the case.
No, we had discussed how mentally ill Mr. Smith was. I mean, we talked about that in great detail. That's why a forensic psychologist was hired, and not just someone who was an expert on the Jimmy Rice program.
But to be clear, Dr. Butler, you were not involved in all the legal decisions that were made by the defense team in this case. You were a witness that they chose to call to the witness stand.
That's correct, but Ms. Schlax and I, we both collaborated with the mitigating circumstances and in developing them, and quite a few involved mental illness. Mental illness was always a mitigation theme. Without pedophilia, it was really unlikely that this offense would have occurred. And so the only reason that we brought, one of the main reasons that we brought in all of that information, which I admit was very damaging and typically would not be brought in, was because Mr. Smith had a long and really stable history of specific diagnoses of major mental illness.
Well, would it surprise you to hear that Ms. Schlax testified in this courtroom that she intentionally excluded you from strategy discussions leading up to the trial?
If that's what she testified to.
Okay. And again, to be clear, you weren't the lawyer in this case. Legal decisions were left up to the lawyers.
Not at all. It was absolutely Ms. Schlax and Mr. Fletcher.
Okay. Now, you actually were allowed, and Ms. Schlax asked the court to allow you to sit at counsel table during the course of jury selection, correct?
That's correct.
As a jury consultant.
Correct.
And you've actually published multiple articles on death qualifying juries, correct?
Correct.
And it was your role as a jury consultant for the defense team that you would make recommendations on specific jurors and your opinions as to whether or not they may suggest a life sentence or a death sentence.
Correct, among other things, but yes, you're right.
You wanted a jury, the defense team wanted a jury that would recommend a life sentence.
Yes.
Okay. And you participated in the discussions with the defense lawyers as to what jurors would be potentially good defense jurors and what jurors would potentially be bad defense jurors.
Correct.
Okay. And in those discussions, because you had Mr. Fletcher, you had Ms. Schlax, and actually the defendant was seated at counsel table as well, correct?
He was.
And there were open discussions throughout the course of both the individual voir dire, where we had single jurors brought in and questioned outside the presence of everybody, correct?
Correct.
And then once we had a group of 100 jurors who were open to the option of both life in prison and death as a potential punishment, those jurors were then questioned as a group.
Correct.
And there was more questioning that was posed to the jury as a whole at that point in time.
Yes.
And you took notes during that process.
I did.
And you made recommendations to the defense as to which jurors to keep and which jurors to strike.
Right. We collaborated as a team regarding our recollections and our notes. Yes.
Okay. And the defense team as a whole agreed and accepted juror number 13 as a prospective juror.
Yes, that is my understanding.
Okay. And in fact, you all believe that juror number 13 would be a good defense juror.
I don't remember juror number. I've been asked to review juror number 13. I don't have a strong recollection of juror number 13. I understand.
Would it help to refresh your recollection with your jury selection notes?
I have.
Your objection, this is well beyond the scope of your act.
I mean, it's a claim that's being posed, Your Honor, during the course of the trial.
We were only addressing claim 5 with Dr. Butler, Your Honor. This is claim 1.
Well, I mean, I could sustain your objection, and then they can call her as a witness. I don't want to have to go through that. Is it okay if we just go ahead and do this, and you'll have the opportunity to cross-examine her?
Well, that's certainly their option, so I'll withdraw the objection.
Okay, go ahead.
Have you had the opportunity to review your notes?
I have.
Okay, and there were no indications whatsoever that juror number 13 would have been a possible bad juror?
Correct. I didn't see any, and again, I don't have any independent recollection of that particular juror.
Okay. You, in fact, when you were called as a witness, you actually wrote your questions that Ms. Schlacks used during your examination, correct?
Yes, Ms. Schlacks asked me to do so.
Okay, and in addition to writing out the questions, you pose what you believe to be will be your answers to those questions throughout the course.
Correct, general answers, yes.
Okay, and so obviously given this opportunity, you had ample opportunity to clarify any contradictions or any issues that existed between Dr. Holmes' testimony and the testimony of other witnesses.
I never saw Dr. Holmes' testimony before I testified.
Okay.
So I
Had the defense believed that your clarification was necessary, they could have easily asked those questions.
sure,
Okay, but they just decided to do so because that was their trial strategy.
that was their decision, correct.
Thank you. I don't have further questions.
Would you like to ask her some questions?
Yes, Your Honor.
Okay, sure.
Now, to be clear, you had had a number of conversations with defense counsel through the years prior to late 2017 and 2018, correct?
Yes, I did.
Okay, and so then they stopped communicating with you, they stopped including you in meetings in late 2017, around the time that Dr. Holmes was opining?
Apparently, I wasn't a member of the discussions with Dr. Holmes. For whatever reason, I have no idea.
Well, you had prepared a list of mitigators as part of your tasks with the defense team, correct?
I did.
So you would have been quite surprised and upset to learn that Dr. Holmes believed that none of those mitigators in fact existed.
Yes, I was surprised and confused when I
And
read
you did
that.
recommend to Ms. Schlacks that she not call Dr. Holmes for that reason.
I did upon reading the deposition. Upon hearing about it, I was concerned, and then when I read the deposition, I thought, is there a way to do this differently?
And when you talked to her about it, what did she tell you?
Again, I think that she said that she'd spoken with Dr. Holmes. Dr. Holmes made her feel better, said some things that made her feel better, and that it was my understanding that Dr. Holmes was going to qualify her testimony in some way. How that was going to be, I don't recall. I interpret it as perhaps, revising Dr. Holmes' definition of mitigation, possibly. That's my interpretation, not what Ms. Schlacks said. And that it clearly did not happen.
She didn't tell you that Dr. Holmes was going to testify exactly the same way as she testified
No.
in depo.
No, she did not.
She didn't say anything about her testimony being a double-edged sword, did she?
I don't recall that term, no. And I know she didn't tell me that, and I don't think she knew that Dr. Holmes' testimony would get more descriptive in an adverse way. So.
Okay. Counsel had asked you about some statements that Mr. Smith had previously made. You responded to that as responses to questions by trial counsel, correct?
I'm sorry, I don't quite understand your question.
You have been asked about some statements regarding his urge to hurt.
Mhm.
Okay. Is it true, though, that statements like that are symptomatic of someone with antisocial personality disorder or borderline personality disorder?
Correct, and they were also in the records as a reason for Mr. Smith's Baker Act.
So they're pretty consistent with the diagnosis that he'd had for decades.
Right.
And those conditions themselves, in your opinion, are mitigated, correct?
Well, yes, it's a widely known mental illness. It manifests in a terrible way in terms of offenses against children, an offense against children often, particularly as when we're talking about it in the context of the legal system, but it is still a widely known severe mental illness that someone doesn't choose and can be managed or treated but not cured, and so it's a mitigating circumstance.
And there are a number of other mental health problems that can lead people to commit crimes.
Yes, of course.
Those are still mitigating as well.
It is. They are, and there's really no such thing as good mitigation or bad mitigation. We don't tend to dichotomize because so many things that are mitigating are mixed bags, or they're complicated. People are complicated, and so we don't often find. Many times we don't have people who are able to come in and say that a defendant has led a law-abiding life, and many family members are supportive and friends and whatnot. Sometimes we do, sometimes we don't. But if we have a lot of mitigation that highlights severe mental illness, abuse, psychological, physical, sexual, family instability, neglect, all of those, substance abuse, addiction, all of those things that we had with Mr. Smith, those are all mitigating factors or mitigating circumstances.
And you had included Mr. Smith's history of abuse as a child and young adult in your psychosexual history, had you not?
Yes, and in the records it was pretty consistent that he had disclosed to several psychiatrists that he'd been sexually abused when he was 8 or 9 by 2 older boys, and then raped in prison by 2 men. And that had appeared for decades, periodically, but for decades throughout the
And in fact, Dr.
records.
Holmes had informed you that he said the same thing to her.
Yes, she informed me by email that if I knew about his first sexual experience, which was sexual abuse by 2 older boys, and I said yes, I did, and then she also informed me of another major mitigating factor, which was remorse, and that he had expressed it to her, and I knew that he expressed the same thing to me, and I thought that was great that they were making headway in terms of rapport, and that he felt comfortable around her enough to say that. So.
And she never gave you any explanation as to why she left those obviously mitigating circumstances out of her report?
No, it was confusing. It was disappointing. I understand again, that we had many different mitigation themes. One of which he should have been committed. He should have been institutionalized. He never should have been let out. But it wasn't to the exclusion of these other things that Mr. Smith had going on in his life, and that was the issue that I had. We had, the mitigation themes are threads that are kind of woven through a mitigation presentation or penalty phase, and we have many different ones, not just one.
And the negative information that you had provided about Mr. Smith's history, that he'd been designated a mentally disordered sex offender and a sexually violent predator, that was in response to questions by his counsel, correct?
Correct.
And the information about his making statements about having an urge to intensely hurt someone, that was also in response to a question by trial counsel.
Correct.
And in fact, he had sought to commit himself to Shands because he was making statements like that. Is that correct?
Yes, 2 weeks before the offense. And that was in the notes that he felt homicidal, and it frightened him enough to want to commit himself to Shands. And I believe they had given him a pamphlet, and a new pamphlet, and told him to read it, and he was released within a few days.
And did it surprise you that that information was also excluded from Dr. Holmes' report?
It did, because I know how important it was to Ms. Schlax, because we really, when we found that information out very early in the case, we really talked a lot about it. And upon looking back, when I was able to watch Dr. Holmes' testimony, and this is after my testimony, I recall Ms. Schlax asking Dr. Holmes about his attempt to confine himself, and Dr. Holmes appeared to have forgotten it. She didn't talk much about it. She kind of minimized it, or kind of she just didn't really talk about it. And it surprised me because it was a huge mitigation theme that we had talked about. It was commitment, and it was Mr. Smith committing himself because he knew that how far down he deteriorated, and that was the one thing that seemed to manage his condition. The other treatments had failed, some due to lack of consistency, some to lack of compliance on Mr. Smith's part, and some to lack of availability. But yeah, that was a big mitigation theme that we had.
And it was certainly Ms. Schlax's intent to get that information out there.
Absolutely, she wanted it highlighted, very much so. That was very important to us because of the proximity to the offenses. It was 2 weeks. Correct.
Thank you.
Thank you.
Nothing.
Cliff?
Yes, Your Honor. To be clear, the questions that were asked of you during the course of the trial, while they were asked by trial counsel, you wrote them and put the answers on the form that you gave to Ms. Schlax to ask you those questions.
Correct. And also, to be clear, we discussed things ahead of time.
Yeah.
Because I'm not an attorney. Ms. Schlax is a very skilled attorney. She knows how to do a direct examination better than many attorneys I know. So we talked ahead of time, and then I wrote the questions. So.
And so there was nothing surprising about your testimony?
Oh no, there was nothing surprising about her questions. I was not blindsided in any way.
And obviously, you're well versed in capital cases and how they're handled.
For the most part, yes.
And you would agree with me that ultimately, what's mitigating and what's not mitigating is up to the jury to conclude in the end.
It absolutely is, yes, sir.
And ultimately, in this case, there were proposed over 100 possible mitigating factors or mitigating circumstances that were submitted to the jury.
Yes, sir.
And out of all those factors, it was only the relationship that Mr. Smith had with his son that the jury actually found to be mitigating.
Yes, sir.
So apparently the jury agreed with Dr. Holmes.
Apparently, they found very little mitigation in this case.
Thank you. No further questions.
Anything further?
No, no.
May Dr. Butler be excused?
Yes.
Thank you.
Thank you for your time.
Thank you
today.
very
We
much.
appreciate it. Can we get an idea about tomorrow?
Is that your last witness?
Yes.
Okay.
Oh, it is? Oh, okay.
Yes, you
Yeah, and so, I can wait for the witness to be excused before.
Okay, because of
There
the
are a couple
rule.
things that
Yeah,
you
we've
put
got
on
the
there.
rule in vogue, so we can't talk about other witnesses while you're still in here, Dr. Butler. Thank you. Take your time. Okay.
So for the record, the defense is resting their case for the purpose of the 3851 evidentiary hearing?
Yes.
Okay. And Your Honor, based upon the evidence that has been presented here today and consistent with our argument that we presented in our written pleadings, we would move the court at this point in time to summarily dismiss the defendant's claims, understanding that fact that the court may not rule immediately at this point in time. We are prepared to proffer testimony that we would present in rebuttal, but however, we believe based upon the pleadings that were presented to the court, our written arguments that are already presented to the court during the course of the Huff hearing and the examinations today, that the defense has not met their burden to establish that, one, that the practices or the conduct of defense counsel did not meet professional standards, and that even then, in the light most favorable to the defense, if it did, based upon the circumstances of the evidence in this case, that it would not establish the prejudice necessary to require a new proceeding, both either for a guilt phase or a penalty phase. And so just at this point in time, I would move for the court to summarily dismiss the charges at this point in time, but we are prepared tomorrow to proffer evidence in rebuttal if the court's not prepared to rule at this time.
So you're saying you're prepared to proffer? I thought you had one witness that would be here tomorrow.
That's what I'm saying. We'll present the witness.
Oh,
We're saying we don't believe the witness is necessary for the legal standard, but we will proffer and put on that witness's testimony.
No, I understand that.
In the abundance of caution, because I don't anticipate the court to summarily rule this afternoon.
Okay. All right, well, we will continue tomorrow. I'm going to deny making that decision right now. How many witnesses do you have tomorrow? I know you have one that you want to call because she's got other responsibilities the next day.
I anticipate we'll be calling Dr. Holmes first, Your Honor, because she has testimony on Thursday down in Daytona. There may be some, the only other two witnesses that we've listed that we anticipate would be calling would be myself, and handled by another one of the trial team, and then also potentially, and we'll have further discussions, Michael Bosson, who also testified as a witness for the mitigation in the guilt phase of the trial. I'm not sure if his testimony based upon cross-examination is going to be absolutely necessary, but he's available and he'll be present tomorrow at 10 o'clock. So I anticipate we'll be able to present our evidence before the lunch hour tomorrow.
Sounds like one way or another we'll finish tomorrow and we won't meet Thursday.
Absolutely.
And the two cases that were on the calendar other than Donald Smith, one has already been passed to April 3rd, and I think when Mr. Skinner comes in tomorrow on the other, I took the paperwork upstairs, but on his case, it'll probably also get passed. It was my understanding that they were going to be passing that one too. So all we have is just to finish this.
Yes, Your Honor.
Okay.
I will confirm with Mr. Skinner. He's going to get with Ms. Wright. I'll make sure they know to be in 406 tomorrow.
Well, the date that Mr. Boston's case, Jasmine O'Neill, was passed to is April 3rd. Okay. If they're okay with that date and you can represent that to the court, they don't have to come. If they want it to be, if they want to take care of it tomorrow, then of course we'll take care of it tomorrow. But if they want it passed, then we can use that date unless they need a different date. If they need a different date, then they can come in and we'll give a different date.
Yes, Your Honor. I'll let Mr. Skinner know.
Okay. So I think we'll be in recess. Is there anything else we need to talk about? Do you need to, does the defense need to speak with Mr. Smith in the back before they take him back? You're good? Okay. All right. All right, we're in recess then. Thank you.
Here's your mic.
Would you